Court officer, I am audible. Court officer.
ಹೇಳಿ ಸರ್.
Audible.
ಆಡಿಬಲ್ ಇದೆ ಸರ್.
Okay.
ಹೌದಾ?
One submission, Your Honor, my lord. The writ petition, GMFC, my lord. Saturday is the son's birthday. I'm filing an application to visit him on that day. There is another order by this court asking the mother to supervise the visitation every Sunday. She's blocked my number and she's not allowing me the child.
Lords, I had filed divorce petition in Shivakasi court. Respondent wife has got it transferred to Bangalore. From last 1.5 years, they are not doing cross, my lords, for speedy disposal.
Which year is MC?
2024 matter, my lords. I
Give it, we'll see it sometime next week.
year number 39, second list.
Huh?
Second
No,
list.
out of the list mentions, yes.
My lord, maintenance, areas of maintenance has been deposited before this honorable court, my lord, in spite.
Yes, yes, yes.
My lord, RPF.
Tomorrow, madam, against NBW shall be there.
My lord,
Yes,
Lord, RPFC filed for enhancement, my lord, 2023, my lord.
it will come next week someday. Yes,
Any date, my lord.
they will give. Yes, next.
Fresh RPFC, my lord.
Why are you giving a memo for a fresh RPFC? If the office
Office is
objections are
compliant.
if it is compliant, it will come. Don't have to give a memo for that. Yes, next.
My lord, serial number 31, list number
We
2.
will call. We'll call the list.
My lord, RPFC, I have filed an IA for modification in the order. To hear on.
Huh?
To hear an IA, I have filed for modification in the order.
Modification of
Order,
which year is RPFC?
24 months.
24 RPFC, again now for modification. Plus somewhere a week thereafter. Yes,
Next.
call the list.
Page wise adjournment, list 1, page number 2, scale number 2 to 5, page number 3, 6 to 9, page number 4, cell number 10 to 13.
Your
page
lordship, serial number 12, seeking a short adjournment.
Why?
Your lordship, the document has to come from the petitioner is residing in Canada, and she has to.
What is this additional evidence?
List number 1.
Yeah, additional documents, further treatment regarding the further treatment. So that has to be presented. Your lordship,
MF,
MFA. Yeah.
Satish
That,
B.
yes, yes. I'm a proxy counsel. I've informed the other side also.
This order is passed by this court.
Yes, your lordship.
This court has passed.
Yes, your lord. I mean, no.
The other bench.
Yes, yes.
Let it be in the list. All those documents are not necessary for the treatment and all. We'll see. It is anyone
Maybe
coming up
posted for admission itself. Your
We'll see. Yes, next.
Page number 5, scale number 14 to 17. Page number 6, scale number 18 to 20.
Oh.
I appear for respondent, 21 matter action, that is your final hearing posted.
19. You're representing whom?
Connected up to the capital line. 19.1.
What happened on the last occasion?
Serial number is 19.
What happened on the last occasion? Why it is adjourned?
Complete the journal.
Huh? No, that I understand. Why is it adjourned on the last occasion? I'm asking.
19.
He is opposing. Why is it? What happened? I'm asking. Last occasion. How many times this matter is adjourned?
Several times is posted.
That's what he's saying. That's why I'm asking you. No representation on 10/6/2025. The proceeding sheets are of this size now. Again, on 14/7, present, no representation for insurance company. The insurance company cannot ask for adjournments. Finally, list this matter next Tuesday, no further adjournments, and no mentioning shall be made for this matter.
Date may be given.
Yes, it will come on Tuesday.
7.
Yes.
Page number 7, serial number 21 to 26. Page number 9, 27. List number 2. Page wise adjournment. Page number 2, serial number 5 to 8. Page number 3, serial number 9 to 16. Page number 4, serial number 17 to 25. Serial number 5. Page number 5, serial number 26 to 32.
Lordships, serial number 31, I appear for the respondent. I've also informed the other side. There is some inconvenience, Your Lordship. Someone passed away in the senior's family.
With request to counsel respondent.
2 weeks time. 2 weeks time.
This is matter on September 18th. Look at it, if interim order is there, extend.
Grateful, Your Lordship.
Serial number 32, Your Honor. The contempt petition is filed before the Chief Justice Court, Your Honor. It has been pending, and the adjournment it is on 1st September and 15th September. We are,
If a contempt petition is filed, why does this matter be adjourned?
the connected matter has been pending, Your Honor.
Who you represent, petitioner or the respondent?
I am opposite the petition, respondent.
Then have you informed the petitioner?
Yeah, we informed the petitioner. She acknowledges also.
Land counsel for the respondent seeks time. It is submitted that the same is informed to the land counsel for the petitioner husband. This is matter on 9th of September. Yes.
Page number 6.
Serial number
Serial number 33 to 42.
39, my lords, permitted to withdraw the petition. Settle out of court settlement as.
The memo is filed stating that the matter is settled between the
That's,
parties. And if they want to withdraw the petition, dismissals withdraw.
Deposited
Memo
amount
is
may be
taken on record.
transferred to first petition respondent.
Why?
The amount has been
As
deposited.
per the
by-
interim order, amount has been deposited.
Who has to withdraw then?
Alert?
That amount who has to withdraw?
First
Respondent.
respondent.
Then let
Minor
them
daughter.
withdraw from here only. Why to transfer it again? If they can withdraw as per your settlement, that I'll record and they will
No,
withdraw.
no, amount is deposited before this court.
That I understand.
Permitted to withdraw the respondent.
As per the settlement, he has to withdraw, is it not? So he will withdraw from here. Why to transfer it to the court again? That's what I'm saying.
Yes, ma'am.
A memo is filed stating that the parties have entered into settlement, and as per the settlement, you're for the wife.
Yes, ma'am.
The wife can withdraw the amount that is deposited.
First respondent is a
Who is
minor
the
daughter.
respondent?
Minor daughter.
On behalf of the
Huh?
Minor-
Minor daughter will not withdraw, represented by
Petitioner will
guardian.
cooperate.
The minor guardian, the amount is, that is for the minor daughter. And as per that, the amount can be withdrawn as per the settlement. Considering the memo that is filed seeking to withdraw, as per the terms of the settlement, the amount can be withdrawn by the respondent. Accordingly, the petition is withdrawn and the respondent is at liberty to withdraw the amount that is deposited before the court. Yes, next.
Serial number 41, my lord.
Page number 7.
Raised 2 weeks adjournment. Petitioner, my lord.
Why?
Settlements are going on, my lord. Settlement.
Where is the other side?
We informed for respondent also, my lord. Respondent.
Land counsel for the
Prima-
petition submits that the settlement talks are going on. No, generally settlement talks will go on in a matter where there is stay.
No, next,
Otherwise
within
it
2
won't
weeks.
go
it
on.
will-
The land counsel appearing for the petitioner submits that settlement talks are going on, seeks 2 weeks time. It is submitted that the same is informed to the land counsel for the respondent.
Interim order. extended.
Is this matter on 23rd of September? Interim order earlier granted is extended till then. Yes.
Page number 7, serial number 43 to 50. Number 8, page number 8, serial number 51 to 55.
Serial number 52, my lord, waiting for a petition. Senior is having some throat infection, my lord, today. On Monday,
Informed to the other side
I have informed, sent a message to other side.
because it is submitted that the counsel for the petitioner is having some inconvenience and the same is informed to the counsel for the respondent. This is matter on 9th of September. In all the matters on request, wherever it is adjourned, look at it. If there is a stay, extend. Yes.
List number 1, parted matter, serial number 1, Pradeep B for appellant.
I am for the respondent in first case and appellant in the second case, my lord. Tomorrow it may be posted, my lord. I have got documents with me. Since due to personal inconvenience, I could not personally present, my lord. If it posted tomorrow, I'll produce the document.
Tomorrow not possible, it is on 20
or Monday.
29th of August.
29th of August.
Yes, much obliged.
At the request of and counsel for the claimant.
Serial number 2. Serial number 2, notice issued.
Who appears? As the counsel for the petitioner has no more, this court has directed the registry to issue notice to the appellant. And the court notice is issued and served on the appellant number 1, appellant number 3, and appellant number 4. And as far as A2 is concerned, as per the postal shara, is no more. Is this matter for dismissal on next Tuesday? Yes.
Serial number 3,
I'm for the appellant insurance company, my lord. We have already complied the office objection on 22/9/22.
No, it is not about office objections, about the process.
Process also we have
When
paid.
was it paid? When was
Paid on
37/20/25? There is an order.
this bill.
On that day, where is it done?
as per order dated 37, it is not done.
The last,
It's not previously. Previous notice is not, now they say, as per the order dated 37/20/25, you have to pay the process. Please pay the process.
Please.
The petitioner shall do the, shall pay the process within a week, or else the appeal shall stand dismissed.
and matter, there are 3 matters maybe, all matters may be connected together.
List along with so and so, give the numbers.
Please.
Yes, next.
Serial number 4, Gangadhar.
Appearing for R4.
Bill memo is served on the council.
No, my lord. No, my lord.
ಕೊಡ್ತೀನಿ sir.
Raise time for filing wakalat next
It may
week.
be taken up next week.
What is this?
A senior is not feeling well. He is not come today. So
Does this matter? Admit post for final hearing. Call for TCR.
TCR is
List on 23rd of September. Next.
number 5, Keshav Rao.
No representation for dismissal on Wednesday next week. Next.
Serial number 6, serial number 6, Syed Abdul Sabur.
This also same order.
Serial number 7,
My lord, I am for appellant. My lord, I filed a memo for dispensation to R2. My lord, as far as R1 is concerned, what is the postal shara? It is not forthcoming, my lord. Third time I have to take steps.
A memo is filed seeking dispensation of notice to R2. This memo is taken on record in the notice to R2 is dispensed with at the risk of appellant. The petitioner shall pay the process as far as R1 is concerned.
R1, what is the?
R1, the process shall be, it is for the third time. R1.
My lord, what is the postal endorsement that is not?
It says it cannot, address cannot be located.
he cannot be located.
Or else as per the postal shara, the address cannot be located. The petitioner shall come up with, the appellant shall come up with application for substituted service of notice on R1 by the next date of hearing. List is matter on 3rd September.
Serial number 8, hearing on interlocutory applications.
Yes.
Chetan DT. B.
What do you
Pradeep.
say will condone the delay on condition?
Delay
I number 1 of 2020.
entered.
Huh?
Not entered for interest for the delay period.
IA number 1 of 20, there is no representation on behalf of the appellant. IA number 1 of 2020 is filed to condone the delay of 429 days in filing the appeal. No objections are filed by the insurance company. Considering the reasons stated, the delay is condoned. However, they are not entitled for interest for the delay for the period of 429 days. Yes, they succeed in the appeal. Yes, next.
Serial number 9, Next
Admit
case,
post for final hearing, call for the TCR.
Delay can be conducted. 23 days delay in 9 and 9.3.
Item
Respondent,
number 1 of 22 is filed to condone the delay of 23 days. Same. For the reason stated, delay is condoned, no condition. What is this? Wakalat for R2? Pradeep.
Pradeep,
Wakalat needs to be
We'll
filed.
file.
Can counsel for this, Mr. Pradeep submits a file Wakalat within a week.
Respondent one also filed undertaking to file wakalat. The headmaster of this school with Jyotia public school.
Notice to R1 is dispensed with.
None manil. Yes, sir.
Yes, next. Admit post for final hearing, call for the TCR.
cell number 10. Cell number 10, Bopanna Associates.
No, there is, in all the matters, the delay of 23 days to be condoned. At 23 days, look at it, 9.1, 9.3 again there is delay.
For admission, cell number 10, Lalta P. Manihal.
Yes. Admit post for final hearing.
Cell number 11, Rangegowda NR.
Who appears for the respondent KGID Bangalore? Huh? What is the name of the advocate? Huh? What is that? Ask him to use the mic. I know, I'm asking government advocate, KGID. The R1 is appear, the R1 is appear by the government advocate. It is submitted that they'll file wakalat in the matter. This is matter next week. Admit post for final hearing.
TCR may come.
Call for the TCR. Next.
Cell number 12, Satish B. 12, Satish B.
Lordship, I'm the proxy
Manjula?
counsel. The
Let's
matter
see what
for
it is.
R1, yeah, for the additional documents,
Let's see.
may be posted for admission after any day after the 5th year.
You're seeking enhancement.
Yes, Your Lord. I mean, I'm a proxy counsel, Your Lordship. The additional documents for further treatment. And the petitioner is in Canada, and she's already sent the documents. It's on the way.
Admit post for final hearing. Call for the TCR.
Much.
Cell number 13,
Appearing for
Abhishek.
R2.
13, Abhishek for appellant.
But in the connected matter, I am for the appellant, my lord, the claimant.
What
For
is
the-
this matter about? Plain report is challenged by you.
By the owner of the,
By the owner.
yes, my lord.
You appear for the owner.
I am for the claimant, my lord. I am for,
Who-
my appeal is for the
Who is
enhancement.
Abhishek K? Where is Mr. Abhishek K? You are for the claimant.
Please, my lord.
Owner is before the court. Where is the counsel?
Hitesh Gowda BJ.
Counsel for the claimant is present. No representation on behalf of the appellant, owner of the vehicle. List MFA 453 of 2023. I think it can be disposed of, or shall I admit it?
My lord, TCR may be called, my lord.
Required? Then admit post for final hearing, call for the DCR. No representation on behalf of the appellant, owner of the vehicle.
Cell number 14,
Much obliged, my lord.
I
Gopal
appear for appellant in this case, my lord. Kindly, my wakalat may be taken on record, my lord. We find NOC wakalat.
Harini Shivananda for R2.
I appear for R2, my lord. I appear for R2, my lord.
It's already there. What is to be accepted?
Sorry, kindly TCR may be called for, my lord. The case has been dismissed in trial court. Kindly TCR may be called.
Admit post for final hearing.
Much obliged.
S15.
Cell number 15. Cell number 15, Syed Abdul Sabut. FS Dabali.
In 15, I number 1 of 25 is filed to condone the delay of 281 days in filing. There is no notice. Mr. Syed Abdul, don't write that. Syed Abdul Sabur is directed to take notice in MFA crop 103 of 2024. Office is directed to print his name. List this matter next week, give some date. Yes.
Cell number 16, Sachin BS, final hearing.
For the appellant, my lords. Case for enhancement, my lords.
Where are the counsels for the respondent? Passover, let inform them.
My lords, I want to rely on the deposition. It's in Kannada, my lords. I might require some time to translate.
MFA is for enhancement of the compensation. What is the deposition?
Payment, my lords.
Deposition in Kannada, you read, he is there, I can understand. For everything, this translation is not required. Yes, Passover 16, 17.
Number 17.
I am appearing for the respondent number 2, my lordship, in this matter.
1 week accommodation.
Why?
Not liability fastened on the owner of the vehicle. I go through
On
the
what
papers.
ground it is fastened on the owner?
Not police traveling in the tractor and trailer. They are not covered on. There is
They're traveling on the trailer.
trailer
They are not covered.
covered. That
Why
is
you
on
want
the
to-
ground that may not
They have not paid the
fasten
fee.
the liability on the owner of the vehicle.
No, for that, why you want time? It's a good case.
1 week accommodation.
1 week, it will not come after 1 week. It will go after in the month of September because the matters can't be adjourned like this. This is matter on 25th of September at the request of non-counsel for the petition appellant. Yes, next.
Cell number 18. Cell number 18.
No
Yes,
representation, no representation for the appellant insurance company. This is matter for dismissal on 10th of September. Yes,
Number 19 adjourned. Cell number 20. Girimalaya.
no representation for
My lords,
dismissal.
I'll appear for appellant in this matter, my lords. My lords,
You
the
appear for?
appellant, my lords.
In which case?
KSRTC, my lords.
Serial number, ma'am.
When is case in 20?
Serial number 20, my lords.
It is connected 20 points.
For R3, counsel for the appellant, no, there is no representation. There is no representation on behalf of the insurance company as well. Counsel for R3 is present. This is matter for dismissal on the earlier date. Yes, 20, next. 21.
Serial number 21. 21. Girish Baldare.
Same, this also for dismissal. No representation.
Cell number 22.
What is happening? Why Pradeep is not representing the cases?
Which?
Earlier, there are two matters.
I'm sorry, my lord, I have not noticed. It is given to me only.
No, but no, that's what there should be representation.
No, no,
before the
he is
court.
held up in court number 5, my lord. That's the reason I have taken all his file.
That's why.
I'm ready to assist the court, my lord, in any cases.
There's 20, there is 20.1, two cases are there, no representation.
No, 22 is concerned.
Insurance advocates are not showing any interest to
No,
argue
no,
the
we are
matters.
ready, my lord, but nobody is come forward. Otherwise, I am
Dismiss
ready.
it. I'll dismiss it. I have no hesitation to dismiss wherever nobody is turning up because court
Please.
will not wait. for
We are
the
ready, my lord, insofar as our case
And
is
you are
concerned.
answerable to your clients if the matters are dismissed.
Please.
Which case? 20?
22.
Cell number 22.
Yes.
In this case, I'm appealing for
Kailash
appointment. We have challenged the quantum here. That the damages
You have
to
challenged the quantum or you're seeking enhancement?
enhancement.
CPPD.
I am
Yes.
seeking enhancement. Madam. It is a case of damages to the vehicle. Madam.
Please come to the order.
Para 16 of the judgment mechanism.
Yes, wait.
My lord, in this case, my lord, para 16, my lord, in page 18 of the judgment.
Yes.
My lord, we have appellant
How
examined a
much,
technical
how
matter.
much amount is claimed?
We have claimed 10 lakhs. Madam.
10 lakh? What is that vehicle that is involved in that, that is damaged?
Damages is a
You
front
wanted
bumper.
compensation of 7,50,000.
50,000 was claimed.
7,50,000.
Court
Court
grant-
awarded only
80,000.
80,000. Madam.
Please come to that particular paragraph where you have stated what are all the damages and what is the evidence.
My lord, para number 15, my lord.
Para number?
Para number 15,
Please
issue number
read.
2.
Please read. Please read.
As per exhibit 2, Maruti car bearing number K05MM1442 at sustained the following damages. My lord.
front bumper, radiator grill, front window glass, both side front fenders, front registration number plate, bonnet pressed, left side mirror, rooftop, front gear glass, post, front door pressed, right side rear bumper, rear windshield glass, tail gate door, rear right side tail lamp, both side rear quarter panel, right side quarter panel glass damaged, radiator and AC condenser found damaged. The petitioner examined the technical manager of the Kalyani Motors as PW2. Though he produced the estimation of rupees 5,33,000 at exhibit P11 and final bill at 4,77,000. Instead of that, court awarded only 2,80,000.
I have read further, I have read already. Para number 15.
Para 16 is very important.
Yes. 14 and 15 also important. It says about whom you have examined as PW2 says that whatever bills that are produced do not belong to their service center.
But tribunal awarded only personal.
That also should have not been awarded in that case.
But what the court has awarded may not declare value of that vehicle. Yes, insured the vehicle in Tata AG, where he has declared value is 2,80,000.
We claimed TPPD, but not own damages.
No, the whole issue in that case is about, as you're saying, 4,77,396 or the bill of 5,33,034. That you have to, by evidence, you have to prove it. That you have failed to prove. And the witness whom you have examined is not supporting your case. He says all those bills do not pertain to our service center. Please come. Agreed with orders passed in MSC number 2319 of 2019 dated 28 March 2021, whereby the tribunal had granted an amount of 2,80,000 as damages to the vehicle. The claimant is before this court. The owner of the vehicle is before this court. The petition is filed, seeking compensation of an amount of rupees 7,50,000 for the damage caused to the Swift car in the road traffic accident. It is the case of the owner of the vehicle is that when he is going to his village at about 6 p.m. A tempo came from the opposite direction in high speed and in a rash and negligent manner and came in the wrong side of the road and dashed against the car. Due to that, the car was extensively damaged. As per exhibit, as per the IMV report, the car had sustained front bumper, radiator grille, front window glass both sides, front fenders, front registration number plate, bonnet pressed, left side mirror, rooftop, front near glass post, front door pressed, right side of the rear bumper, rear windshield glass, tailgate door, rear right side tail lamp, both side rear quarter panel, right side quarter panel glass damaged, radiator and AC condenser found damaged. In support of his case that he had spent amount towards the repair of the vehicle, he had examined technical manager of Kalyan Motors as PW2. Produced the estimation of damages for rupees 5,33,034 as per exhibit P11 and final bill for rupees 4,77,396. The PW2 has admitted in the cross-examination that the documents produced do not contain the gate pass and as such they do not pertain to their service center. And the court has also observed that exhibit P11 and P12 do not contain the seal of the service center. And PW2 has not produced any documents to show payment receipt of the amount of rupees 4,77,396. Further, the court has also observed that the RW1 has produced the insurance policy of the car at exhibit R1 and stated that the insured declared value is rupees 2,80,000 and that no claim has been registered for own vehicle damage. And if any claim is registered, the insured will be given the maximum liability, that is a vehicle declared value only. Hence, the court has awarded 2,80,000 towards damages. The claimant has stated that because the car is damaged, he is using the taxi by paying 1,000 per day to attend his business. Even in that regard also, the court was not satisfied and granted compensation of an amount of rupees 2,80,000. Next part. Learned counsel appearing for the appellant submits that when he has produced the exhibit P11 and P12 to show that what are the amounts spent by the appellant for the damages of the vehicle, for repairing the vehicle, the court, without considering the same, had granted only 2,80,000. It is submitted that the court ought to have considered the evidence on record and ought to have granted the amount as claimed by the appellant. Next para. Learned counsel appearing for the insurance company submits that court, basing on record and basing on the evidence where the witness has not supported the case of the claimant, had rightly granted only an amount of rupees 2,80,000 and there are no grounds to interfere. Next para. Having got the counsels on either side, there is a material on record. When according to the claimant, he is seeking compensation of 7,50,000. The burden lies on the claimant to prove that he had spent the said amount and is entitled for the compensation. In support of his case, he has placed before the court exhibit P11 and P12, and also he has examined PW2. When the entire case rests on the evidence of PW2, when PW2 has given evidence that exhibit P11 and exhibit P12 exhibit P11 and P12 do not contain the seal of the service center and they do not pertain to their service center, the petitioner and the petitioner is not able to prove his claim by any other evidence. In those circumstances, court had rightly considered the evidence and rightly granted, basing on exhibit R1, an amount of rupees 2,80,000.
Then submission towards conveyance and transport and charges for hiring a taxi to attend his business when his vehicle was stationed in service station. That is also not awarded anything. Only 280 is awarded.
And when it comes to the parking charges per day by engaging the taxi of rupees 1,000, the court will grant some amount for that.
Can be.
Okay.
Only presumption.
That's what. So how many days it was?
That was not.
How much?
It was not disclosed.
That is not.
He says that 1,000 rupees for paying that acknowledgement or receipt was not placed.
No, that's why.
So only guesswork can be granted. Huh? Considering the nature of damages, guesswork can be.
That's what I'm asking. How much it would be?
10 days or 15 days.
So 15,000. What did you write? The court has not granted any amount on the ground that no receipts are placed before the court. Considering the damages to the vehicle and the fact that when the owner is using the vehicle and as the same is damaged, he has to engage for his transport, he has to use some other vehicle. Though there is no evidence, this court is inclined to award an amount of rupees 15,000 towards the same. Accordingly, the appeal is partly allowed. partly allowed by granting another 15,000 towards the parking charges. No, towards the transportation charges. That is 2,80,000 plus 50,000, 15,000. That is 2,95,000. Accordingly, the appeal is partly allowed.
So
Next.
number 23, Shantraj K for appellant, D. Vijay Kumar for respondent.
Where is Mr. Shantraj? Is he not coming to the court?
Shantraj.
Not seen.
From the last couple.
He's end up in court number 5.
Passover.
So
Inform
number
him.
24.
Please, my lord.
Yes.
24, Ravi Shankar Shastri Ji for appellant, Janardhan Reddy.
Yes.
My lord, the case of injury, my lord, on the two issues, my lord, the claimant is in appeal. One, my lord, a claim petition was dismissed on the ground that, my lord, there was a delay of 5 days in lodging the complaint.
Oh, claim petition is dismissed.
Yes, my lord.
How many days delay?
5 days, my lord.
Then,
my lord, the MACT holds that, my lord, the rash and negligent driving of the offending auto rickshaw was not proved. Third issue holds that, my lord, as per the evidence of RW1, there was no valid driving license. Therefore, insurance.
To the claimant.
My lord, no, my lord, offending auto rickshaw.
Please come to the order.
Please.
First of all, with regard to the delay.
My lord, para 10 onwards, my lord.
Please read.
During his evidence, the petitioner has reiterated the averments of the claim petition and contended that he had met with the road traffic accident due to actionable negligence on the part of the driver of auto rickshaw bearing number K19D1323. Further, the petitioner has examined one witness, namely Shri Dikshit, as PW2 in the case on ground that he is an eyewitness to the accident in question. Even PW2 in his examination in chief has reiterated the version of the petitioner and stated that the driver of the auto rickshaw in question was responsible for the accident. On going through the written statement filed by the respondent number 2, it becomes clear that they have not seriously disputed the accident or involvement of the vehicle bearing so and so and K19D1323 in the said accident. Further, though notice of this petition has been served on the respondent number 1, he has not chosen to appear before the court and to contest the petition. Even then, the initial burden is on the petitioner to prove the alleged actionable negligence on the part of the driver of the auto rickshaw in question, so as to prove his entitlement to claim the compensation. As this,
when is the date of accident?
Please, my lord. Date of accident was, my lord, on 8/5/2020.
8/5/2020. Time?
My lord, it was, my lord,
4 p.m.
So immediately after the accident, what has happened?
My lord, immediately after the accident, my lord, he has taken treatment as an outpatient. Then, my lord, noticing that there was fracture in the.
Where is that outpatient? In which hospital?
My lord, in the same hospital, AG. My lord,
what is that? Name of the hospital?
Please. That is, my lord, Justice K.S. Hegde Charitable Hospital. K.S. Hegde Charitable Hospital, my lord, Mangalore.
What are the injuries sustained by him?
My lord, the injury sustained was, my lord, there was a fracture of, my lord, ankle, my lord, bone.
At what time you were what the time is mentioned?
Please, my lord.
Time is mentioned in the card.
Admission card,
to the hospital.
Hospital card. My lord, hospital, my lord, I was as inpatient, I was admitted on later date, my lord.
Please give that. You have.
Please.
TCR is there. Give it. What are the exhibits marked?
Please. Date of admission was 12/5, my lord.
So exhibit P1 is a certified copy of the FIR complaint. Wound certificate is exhibit P3.
Yes.
Let's see P3.
P3 says, my lord, RTA. That is on dated, my lord.
Let's see. P3. This is pertaining to 12/5/2020.
Yes, ma'am.
12/5/2020. What it says, the following injuries which lacerated
secured
wound,
lacerated wound over the right heel
swelling
of
and
swelling
discharge,
and discharge.
X-ray,
Then
ankle
X-ray
of
and
foot,
right knee and
lateral
foot,
malleolus
lateral
fracture.
malleolus fracture and third metatarsal
What is
fracture.
the first one?
This is the
Intimation to the police about accident injuries on
yes,
what date?
that is on my lord 12/5 my lord. On the date of admission.
Now come to this intimation to the, what is that marked as?
Exhibit P4 my lord.
Please come to P4.
Please my lord. To the station of officer so and so, address so and so, brought by name Uday Kumar Shetty, nephew, so and so number, place and time of accident, alleged RT on 8/5/2020 at 4 p.m. at Maddur was brought to Kshema casualty at 12:15 a.m. on 12/5/2020 by Uday Kumar Shetty, nephew, admitted under Department of Ortho.
What is this this motor vehicle report says?
My lord, IME report says, my lord, there were damages to both the vehicles, my lord. My lord, the involvement of the vehicle is not disputed, my lord. Their entire contention, my lord, even in the written statement as well as in the evidence of RW1, my lord, was the.
No, I'm asking you, where is that first outpatient card?
That is not there, that is not marked.
So you were, even in the order also, the court has observed that you're not disputing the accident at all.
Because as per the delay, my lordship, they have not established that the alleged action is caused due to my insured vehicle. As per exhibit P4 also, there is clearly stated that which.
No, if you say delay is one aspect. If you say that a particular vehicle is not involved in the accident, generally also you will take a stand that vehicle is not involved, we are not liable and all. So if you have not taken, there are damages to both the vehicles. So why should we say that it has to be disbelieved? Mere delay in all circumstances can't be the reason to.
Yes, my lord, I agree, my lordship. Because but first intimation, the police information as per police.
Also have to consider whose case is that. It is nobody's case that accident has not taken place.
At least they have to say which vehicle was caused the accident. My lord, so exhibit P4 nowhere stated that the vehicle.
Look at the order. The court's reason is not that.
Yes,
court simply says that because the vehicle the delay is there. So number one, the delay aspect cannot come. No, second aspect is.
Second aspect, MACT holds, my lord, MLC registry is not produced, which is opposed to exhibit P4. Third reason, my lord,
No, with regard to the rash and negligent driving of the opposite vehicle, what was the evidence?
My lord, evidence is PW2 eyewitnesses evidence was tendered.
Oh, it is not considered.
My lord, MACT holds eyewitness says there are 3 other persons and he has not stated about the name of other 3 persons. Therefore, his evidence cannot be believed.
Let's see that.
Please.
Paragraph.
Para 14, my lord. Further, though the charge sheet marked at exhibit P8 claims that there are 2 more
Yes.
Para 14, my lord, Further, though the charge sheet marked at exhibit P8 claims that there were 2 more eyewitnesses to the alleged accident, the materials on record do not probabilize this aspect. It is because the petitioner herein has examined one of such witness, that is CW3, Shri Dikshit, as PW2 in the case. During his examination in chief, PW2 has stated that immediately after the accident, he had, and the persons gathered at the spot had shifted the petitioner to Justice K.S. Hegde Hospital for treatment in very same auto rickshaw which was involved in the accident. During his cross-examination, PW2 has stated immediately after the accident, he and the driver of the auto rickshaw in question, along with 3 more persons at the spot, had taken the petitioner to Justice K.S. Hegde Charitable Hospital for treatment. It is to be noted that PW2 has expressed his ignorance about the names of other 3 persons at the spot. This tribunal does not find valid reason to accept such claim of PW2 as it is against the normal conduct of a person. Added to the above, admittedly, the name of PW2 is not found in the record of the hospital as the person who accompanied the injured. Further, PW2 has not whispered anything about the presence of CW2, Shri Nitin, or any other relative of the petitioner at the place of accident.
This one is a very crucial aspect with regard to why you have not placed the record with regard to the first hospital you went.
My lord, for the reason that, my lord, the fracture was not disclosed, my lord. Therefore, my lord, taking as treatment as a outpatient, he left the hospital, my lord.
You will have some material for that, some paper, something we would.
Yes, that was not placed, my lord. But here is a case where, my lord, involvement of the vehicle is not in dispute. My lord, police record, investigation, charge sheet, everything, my lord, was against the offending vehicle. Spot sketch also shows that, my lord, auto rickshaw came to the extreme right side of the vehicle, crossing the, my lord, the middle portion of the road and caused the accident. And, my lord, to prove the, my lord, this aspect, PW2 eyewitness, who is the also a, my lord, shown as eyewitness to the charge sheet, was also examined. But sufficient materials were my lord, produced on preponderance of probabilities to show that, my lord, the accident has taken place due to the rash and negligent driving of the offending vehicle. My lord, materials were produced. Now, disbelieving that documents, my lord, is erroneous approach of the MAC. It is my respectful submission, my lord. No doubt there may be some loopholes on the part of the claimant in not producing, my lord, initial medical record.
So how many are the injuries?
Please, my lord.
How many are the injuries?
There was one injury, my lord.
One previous injury?
Yes, my lord. Fracture of lateral malleolar and third metatarsal head.
How many days he was in hospital?
My lord, he was inpatient in the hospital, my lord, for a period of
8 days.
8 days.
You have not examined the doctor?
I have not.
No disability?
No. 64 years man, my lord. 64 years old man, my lord.
64 years?
Yes.
What he was doing?
My lord, his evidence was that, my lord, he was an agriculturist and earning rupees 20,000 per month.
Which year is the accident?
8/5/2020.
8/5/2020,
my lord. MACT takes the income as 7,500, my lord.
Medical expenses, no evidence.
My lord, medical evidence was produced, my lord, to show that, my lord, he has spent about 99,843. But MACT holds that, my lord, since he had a, my lord, personal accident insurance, and he has taken from that insurance, claim was negativated.
Yes. What is this loss of future medical expenses?
30,000 was claimed, my lord. Doctor was not examined.
So at best it would be that 1,03,500.
90,000 was awarded by MACT.
Yes, because they are not established, my lordship, by issue because there was a delay. I'll agree, my lordship, there is a, but immediately after that, where he was taken treatment, with the piece of document, at least they have produced, they have not produced the piece of document in my lordship because of the injury sustained by the.
Once we accept that the injury has taken, he met with an accident in a particular, in a road accident, he has sustained injuries.
Right.
So non-producing of that document will not be fatal. If we say, if the court gives a finding that there is no evidence with regard to that accident, it's a different aspect. Now the complaint, FIR, charge sheet, everything against the offending vehicle and the driver. In spite of a notice, they have not appeared before the court. So as far as the accident is concerned, it is established. Once it is established, and the evidence, what the court has given is pain and suffering 40,000, transport, nourishment and attendant 10,000, loss of income during the laid up period 43,500, legal expenses 10,000. It comes to 1,03,500.
Amenities lordship may grant, my lord. Loss of amenity.
For what amenities?
My lord, there was fracture,
Well,
my lord.
without even examining the doctor.
MACTS
What
award. My lord, MACTS
But
award.
will not award.
Also, there was no driving license as on the date of my insured vehicle, my lord.
So that is, where is that? Then
Yes,
the pay and recover will apply.
Yes.
Where is that?
Para 31, my lord.
Want to show that the respondent number 1 was holding a driving license to drive the transport vehicle from which had validity till 15/5. 2018. Accident was on
2020, my lord.
2012.
My lord, 8/5/2020. Then further it was renewed, my lord.
Subsequent to the accident was renewed, my lord. Date of accident, there was no DL instruction.
Pay and recover. Please come. The claimant is before this court. Agreed by the dismissal of the claim petition in MVC number 1326 of 2020, dated 8th March 2021. The claim petition is filed seeking compensation of an amount of rupees 5 lakhs for the injuries sustained by the claimant in the accident. It is a case of the claimant that on 8/5/2020 at about 4 p.m., when he was going on a motorcycle and an auto rickshaw came at high speed in a rash and negligent manner and dashed against a motorcycle. As a result, he has sustained serious injuries. Immediately, he was taken treatment as a outpatient in Justice K. Segde Charitable Hospital. And thereafter, he joined in the other, what is that hospital?
Same hospital.
In the hospital as an inpatient from 12/5/2020 to 25/2020 and spent more than rupees 1,30,000 towards his medical expenses. And also requires further amount for his future medical expenses. In support of the case of the claimant, he has examined himself as PW1 and another eyewitness as PW2. Exhibit P1 to P12 are marked. On behalf of the respondent, RW1 is examined and exhibit R1 and 2 are marked. That is insurance policy and the extract of driving license. The insurance company has filed its objections and the insurance company do not dispute the accident. However, according to them, the driver of the vehicle is not having a valid driving license. Driver of the opposite vehicle is not having a valid driving license. In those circumstances, the insurance company is not liable to pay the compensation. And the court, by order, impugned and dismissed the petition on the grounds that the accident had taken place on 8/5/2020 and the medical records are pertaining to 12/5/2020. And even the FIR was registered thereafter. Further, as there is a delay in giving the complaint, it was not considered. The evidence of PW2, who is examined, who is alleged eyewitness, was not considered because he has failed to state about the other persons who were present at the time of accident, and his name is also not shown in the medical records that he is the one who has taken the injured to the hospital. And the court, when it comes to the compensation, had granted an amount of rupees 90,000 and dismissed the petition. The learned counsel, appearing for the claimant, submits that when there is no dispute, when the insurance company itself is not disputing about the accident, the court ought not to have conducted any, ought not to have gone into the said aspect. It is submitted that the court without any basis has gone to the said issue. It is submitted that without any basis, the evidence of PW2 is disbelieved. Further, the amount of compensation that is determined by the court is also not just is also not a reasonable compensation, and the claim petition ought to have been allowed. and ought to have granted a reasonable compensation as well. When counsel appearing for the respondent insurance company submits that the court had rightly dismissed the petition. It is submitted that when on the same day, when he is admitted in the hospital, in Justice Hegde Memorial Hospital, on the same day, then there is no scrap of paper is placed before the court to show that he was admitted. Then all the medical documents are pertaining to 12th when he is admitted in the hospital. The court had rightly considered this and rightly held that they are not entitled for that they have not established the involvement of the vehicle. Further, it is submitted that as on the date the accident had taken place, the driver of the offending vehicle was not having a driving license, as the same expired long back. Even on that count also, insurance company is not liable to pay the compensation. It is submitted that the court had rightly dismissed the petition and there are no grounds to interfere. Expired. Having heard the counsels on either side, there is the material on record. The court has to frame the issues basing on the pleadings of the parties. Here in this case, it is the case of the claimant that the accident had taken place on 8/5/2020, and the respondent insurance company had filed their objections. They have not disputed the involvement of the vehicle or the accident that had taken place. In that case, the court ought not to have gone into the said aspect. Then the court has to look into whether the accident had happened because of the rash and negligent driving of the driver of the offending vehicle. If that issue has to be looked into, the PW2 is examined, and the police records also supports the case of the claimant that the accident had taken place and the charge sheet is filed against the driver of the offending vehicle. In that view of the matter, this court is of the view that the issue with regard to whether the accident has taken place or not, or the delay in giving the complaint, will not go to the root of the matter. And in the considered opinion of this court, the accident had taken on 8/5/2020. The next aspect is considering the police records. There is a negligence on the part of the driver of the vehicle, opposite vehicle, and PW's evidence also supports the same. Hence, the negligence is fastened on the driver of the offending vehicle. When it comes to the compensation, he has sustained one grievous injury. Hence, hence an amount of rupees 40,000 is granted under the head of pain and suffering. Considering the hospitalization, transport, nourishment, and attendance charges, and considering the notional income at 14,500 for 3 months, it comes to 43,500. In the light of the law laid down in Mekala versus so-and-so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 1,01,500. Next, coming to the aspect of the driving license, as the driver of the offending vehicle is not having a driving license on the date of the accident, the insurance the principle of pay and recover apply, and the insurance company shall pay the amount and shall recover the same from the owner of the vehicle. The amount will carry 6% interest.
Number
Yes, next.
25, A. Venkatesh for appellant, Anand Darby.
And for respondent.
You are arguing, yes. On what ground the insurance company is before the court?
Liability. The quantum is concerned, madam.
What is the judgment, pay and recover?
Rani case.
Rani. Rani versus? Rani versus?
Rani versus National Insurance Company. We had a judgment.
Next, that's the first aspect. What is That is there, you see, in the list of the judgment. Case number 2.
Blood, regarding quantum is concerned.
The case of death or injury.
Injury, it's a case of injury of a minor,
Come to the table.
please. Blood, pain and suffering 50,000.
Page number.
Page number 21 of the judgment, madam, in page 34.
Why not Mallikarjun's case be applied to
That has
this?
to be applied, madam, not only for that, madam.
What is
15%,
the disability?
15% disability was assessed by the doctor.
Give the judgment, Mallikarjun's case.
15% disability was assessed by the doctor.
Judgment.
For that, my lord, court has taken future prospect. Another point, my lord, he is a minor boy of 8 years at that point of time. His income was taken
The judgment.
2008 is.
This, my lord, earlier the MF has been preferred, my lord. This court has remanded back to the trial court, my lord, to examine the doctor. But therefore, my lord, this court has remanded matter. The doctor has been examined. Plus the judgment, my lord.
No, that's true. That is remanded.
This is the second
No,
round of litigation according.
That I understand. No, in case of a minor disability, case of disability, why not Master Mallikarjun's case be applied? It can't be like any other case. That's what is holding the field as of.
The boy is 7 years, my lord, at the time of
That's
the
what,
incident.
minor case only, minor boy only. What it should be, if it is 10%, 20%, that is enumerated, that is there in the judgment. How the court, let us see, if that is calculated that way, how much it is. Mm. 1 minute, we'll take the judgment and we will have the copy. Disability is 15%.
15%.
1 minute, we'll make the calculation looking at the. And you will forget what the court has taken. We will look at what is to be done now. So. Difficult to have an accurate estimate, so and so. Attendance should be, if the disability is above 10%, this is above 10%, and up to 30% to the whole, but 3 lakhs. So, pain and suffering, 3 lakhs. Then, discomfort and loss of earnings to the parents during the period of hospitalization. Which year is this?
2008.
1.
28 days inpatient.
28 days you are in hospital. So 2008 means it is 4,500.
28, sir.
So even if we take 5 months also, 4,500 into 5. It comes to 22,500. Then medical expenses?
1,91,000.
Huh?
1,91,000.
Medical expenses. There is a table, 1,91,560. They were there in the same thing we can continue, special diet and all, attendant and all, the same amount as the court has granted. Traveling, miscellaneous, 33,000. Then future medical expenses, any evidence? Any surgery is done?
Surgery was not done.
No, surgery is done.
Conservative treatment was given.
But
No, is it the evidence of the doctor that any future operation is required?
no, not that.
So in that case, it's coming to 5,47,060. How much is awarded?
8,19,080 rupees, 6% per annum.
So it has to come to this. I'll pass over. If you want, you can look at it.
Discussion. 230.
230.
Till number 26. Srinivasa
Keep this paper in this. Huh? Huh.
27.
26 mother.
No. Insurance company is on what ground? Huh. So pay and recover has to be applied. That's the only ground. Now please come to the table. Where is it? What are the injuries? How many fractures? Removed. Huh? Please switch on your mic. Yes. So generally, towards the pain and suffering, we take 40,000 for one injury. Now, because it's a crush injury, court has already taken 70,000. So there's no enhancement on that. What do you say? How much it can be increased?
Allowed. 57, 80% has been taken. Income has also rightly taken by the criminal. There are no other grounds except.
No, we are on the pain and suffering.
Yes,
what do you say?
on the ground of pain and suffering, this court can ask.
How much?
Another 50,000.
Another?
With for fresh injury, another 50,000.
15.
50.
So we'll have 90,000 on under the head of pain and suffering. The medical expenses as it is. 1 minute. 1,20,466. How many days he was in hospital? Then we'll grant another 5,000 on that. Court has granted.
Yes, my lord.
Attendant conveyance. Loss of income. Income is taken as? How many months granted?
Only one fracture.
Huh?
Only one fracture. 3 months they have given, my lord.
We'll grant one more month. 14,000 into 4.
4.
1 minute, let me complete it.
Wait.
56,000. Then loss of amenity is also rightly granted.
Rightly granted, my lord.
40,000. No, we'll come to that. We are on loss of amenity. 40,000 is a reasonable amount.
Yes, my lord.
Then loss of earning due to permanent disability. Loss of future earning. Disability is how much? 55 limb. And what is whole body disability?
Court has taken 18%, my lord.
So we are granting the disability if it is about 20%.
The court has rightly granted, my lord. And also one more point, my lord. The petitioner has no driving license at all. It has been come in the record. There is an evidence, my lord. He admits that in the cross examination. He has no driving license at all.
Claimant.
Yes,
claimant is not having.
He is not having a driving license, my lord. That is very important. I am not denying.
No, might be. Then if you are not having, that's a fact. That can be established at any point of time.
Yes, it is there, my lord. The evidence.
So then we'll restrict this also to this.
There should be a contributory negligence, my lord. That's why I said I himself has in.
Then we'll do one thing, instead of interfering with loss of future earning, loss of amenities, another 20,000 will grant.
Yes, madam.
60,000 towards loss of amenities.
Pain and suffering, 70,000 has been granted, my lord.
Which one?
Pain and suffering, 70,000 has been
The
granted.
crush injury.
Crush injury. That's why I myself has informed the court.
It comes to 7,30,581. What is granted? 6,71,586. Please come. Agreed with the award passed in MVC number 1626 of 2019. Dated 7th March 2022. Both the insurance company as well as the claimants were before this court. The claimant's appeal for enhancement is MFA number 6284 of 2022, and the insurance company's appeal is MFA 5507 of 2022. The insurance company is before this court on the ground that the driver of the offending vehicle is not having a valid driving license to drive the vehicle, and the court had still fastened the liability on the insurance company. Next, the claimant is before this court questioning seeking the enhancement of the compensation. Learned counsel appearing for the petitioner submits that the tribunal had granted compensation of an amount of rupees 6,71,586. As per the wound certificate, discloses that there is a crush injury on the right foot with severely comminuted metatarsals and phalanges with loss of vascularity of second, third, fourth, and fifth toes, and necrotic skin of sole and other injuries which are grievous in nature. It is submitted that he is working as a agriculturist, and the court has not granted future prospects. The amount that is granted under the head of pain and suffering, loss of amenities, is on the lower side. As he was hospitalized he was in hospital for 11 days. Even at the head of attendant and other charges, the amount that is granted by the court is not a reasonable compensation. It is submitted that he is a farmer, is an agriculturist, and all the injuries would have an impact on the claimant. All these aspects ought to have been considered by the court and ought to have granted a reasonable compensation. Next para. Having heard the counsels on either side, there is a material on record. The court had considered the injuries and granted the compensation of an amount of 6,71,586. Under the head of pain and suffering, court had granted 70,000, considering the crush injury and the loss of the toes. Under the head of pain and suffering, this court is inclined to grant an amount of rupees 90,000 towards medical expenses, basing on the evidence court had rightly granted compensation and no enhancement is called for. Considering the 11 days of hospitalization, under the head of food, nourishment and attendant charges, this court is granting 11,000. Coming to the loss of income during the later period, considering the crush injury and considering the injuries that are sustained by the claimant for 4 months, this court is inclined to grant at 14,000, 56,000. Then coming to the loss of amenities, as he is a agriculturist, and though the disability to the whole body is 18%, as it would have an impact on his day-to-day activities. Under the head of loss of amenities, this court is inclined to grant 60,000. Coming to loss of future earning due to disability, court had rightly considered and granted 3 lakh, an amount of rupees 3,93,120, and no interference is called for. Under the head, the claimant is entitled for an amount in the light of the law laid down in Mekala versus so and so, legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 7,40,581. Accordingly, the appeal of the claimant is partly allowed by enhancing the compensation from 6,71,000 to 71,586 to 7,40,581, and the appeal of the insurance company is partly allowed, holding that the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. The amount in deposit shall be forthwith transferred to the court. The amount shall carry 6% interest. Yes, next.
Till number 27, Srinivasan MY.
Yes. Yes, Pradeep. Hmm. Hmm? Hmm. Hmm. Is it permissible? Take that. No, legal position. Is it permissible? No, I'm asking you. Now he has already claimed the insurance. Once he has already claimed the insurance, according to him, part of it is satisfied and part of it is still he needs to have. So can he file a claim petition against the other vehicle? That's what he's submitting precisely now. Law is different. I'm asking you on a legal aspect. Is it permissible? Huh? Judgment of the Supreme Court. Hmm.
This insurance will not pay the entire amount. That was not based. Six is when the amount was received by the right notice private limited is 1,56,780. I have paid two online payment where one is 80,000, another is 76,000. The tribunal was expected that is not examined the other of the exhibit 3, 7 and 8. Sir, I have heard the amount was paid to online and deducted in my debit card. I have paid in addition happening also. My balance sheet also was in this case to addition. The balance sheet, those amount was deducted in my account.
1 minute, 1 minute. Please come to the relevant paragraphs. Yes.
It's pertinent to note that petitioner has not examined the authorized person who issued the finding.
What is wrong with that finding? No, some document you place before the court and court will not take it on its face value. Till
Kindly see that my additional document also. In additional documents, I have produced the balance, my account statement. In account statement also directed the same tally with exhibit 7 and 8 to balance sheet.
18.
As stated, the court petition has already received claim amount towards legal damage of insurance based on the bill issued by elect members. So, when the petition already received claim amount from the insurer, we cannot again seek compensation amount from the insurer of the amendment. That's why I have produced.
What is that you have received from the other earlier, from your insurer? So what is the remaining amount?
Remaining amount is 83,794 plus 15,000 adjournment charges. 98,794.
The claim petition is filed for what? What amount? Your claim 3,16,790. No, as far as this is concerned, no, as the exhibit P7 and P8, what else you require? No, not only a particular amount is debited to their account.
Unless exactly by those with correct liability, whatever the cost he has incurred due to the negligence of my driver. He has received the amount from the insurance company. Insurance company will engage the surveyor. He will assess based on that they will pay, make the payment. Whatever the difference amount from the surveyor, I am liable to pay. Not from the bill which was raised, because bill will be raised for repair the vehicles.
Then we'll remand the matter. All this exhibit P7, P8, for what purpose they have given, I mean, they have taken this money, they will also be having the account. So it's easy for you to prove it. No, that I have seen. If the insurance company accept, basing on that, the court has no problem to pass an order. But when they say that how many cars he is having, for what car it has, it requires evidence then. Please come. Agreed with orders passed in MVC number 1066 of 2019 dated 30th June 2023, whereby the claim that is the claim petition is dismissed by the tribunal. The claimant is before this court. The claim petition is filed seeking compensation of an amount of rupees 3,16,794. The what is that? For the damages sustained to the vehicle in the road traffic accident. It is the case of the claimant that from his insurer, he has already received an amount of rupees 73,000 as compensation. And the remaining, according to him, as for exhibit P5, letter issued by the Elite Motors Private Limited shows that 1,56,794 has been received from the petitioner in exhibit P5. Huh? No, it has to. Both of that corroborate, isn't it? To repair of the car, and exhibit P7 and P8 are the vouchers. Exhibit P9 is the bill towards the towing charges. The court had dismissed the petition on the ground that he has already received an amount of rupees 73,000 from his insurer, and in the light of the law laid down in decisions in case of New India Insurance Company Limited versus Sharmila Devdas and others, reported in 2007, 1 MAC 823, and DT Narayana Swamy and another versus National Insurance Company Limited and another. When the claimant has already received claim amount from the insurer of his vehicle, he cannot seek compensation amount from the insurer of the offending vehicle. Hence, in view of the same, petitioner is not entitled for compensation. When counsel appearing for the petitioner, claimant submits that the evidence clearly shows the exhibit P5, exhibit P6, P7, P8 clearly shows that the amount is debited from his account and they have received an amount of rupees 1,56,794. As he has already received an amount of 73,000, the remaining amount has to be paid by the insurance company. The court, without appreciating all the aspects and the evidence on record, had dismissed the petition by misplacing reliance on the judgments referred to supra. It is submitted that when the claimant had spent huge amounts, he is entitled for recovery of the same. Next paragraph. When counsel appearing for the insurance company submits that the court has rightly held that, as per exhibit P5, the claimant had not examined anyone in support of his case. It is submitted that in these cases of vehicle damage, the insurance company will upon this. It is submitted that not examining the insurer as well as the insurer, not examining the surveyor as well as not examining the personnel from Allied Motors Limited in support of the exhibits, court has rightly dealt with and rightly dismissed the petition. There are no grounds to interfere. Next paragraph. Having heard the counsels on either side, produce the material on record. The claimant is relying on exhibit P5, exhibit P6, 7, 8, 9 to show that he has paid certain amounts, and from his insurer he has recovered only an amount of rupees 73,000, and the remaining amounts have to be paid by the insurance company. Has to be paid by the insurance company. The submission of the learned counsel to the respondent that he has not examined the surveyor, he has not examined anybody from the Light Motors Private Limited. Also, the submission has some force in it. The respondent ought to have examined the concern. Considering all these facts, this court is of the view that this is a fifth case where the matter has to be remanded back to the court or to the tribunal, giving an opportunity to both the parties. Accordingly, the order dated so and so is set aside, and the matter is remanded back to the court for fresh consideration, and both the parties are at liberty to adduce evidence. Without further notice, the party shall appear before the court on 9th of September. Yes, on 9th of September.
Part that matters, cell number 1, Sumitra N.
Yes.
For petitioner, Chetan Kumar.
What is that? That mic is switch on or not? Why am I not able to hear you? Yes.
I'm audible now.
Now you're audible. Yes.
Based on the record placed before this honorable court, the court was pleased to order 6,000 interim maintenance to the respondent. And we were paying the interim maintenance once the order was passed. In between, we, as I submitted earlier session, in between, since they had taken the proceedings for more than 1 year to lead their evidence, we had requested the family court to stop the interim maintenance. Otherwise, you please instruct the petitioner to run the case without any further delays. After the instruction of this honorable court, we were cleared the interim maintenance as on July this. In spite of me having the financial crisis, like after the marriage, there's a loan. I mean,
here is your MC.
Sorry, Your.
Which year is their MC?
MC. Criminal miscellaneous one.
Oh, when is that?
It is for 2021.
Which court is this?
It is 6th Additional Family Court, Your Honor. From then onwards, we were
From when the respondent is not appearing before the court or not proceeding with the matter, from what date?
I had filed the memo before this honorable court also, Your Honor. If you can refer the page number 8 in the last
Where is that memo? Memo dated 29/7?
Yes, my lordship.
Yes.
I had filed two memos, in fact. The first memo was filed in dated 12/10/23, informing the court to instruct the petitioner without 26. If the lordship can refer 25 and 26, that is the first memo which I filed dated 12/10/23, my lordship.
So from 24/20/23 till now, nothing has happened.
And yeah, as on the last hearing date, they could finish their respondent evidence, Your Honor.
While disposing of this, will say that unnecessary adjournment shall not be granted.
And twice, let me finish. After which, again, one more petition, one more memo was filed, but for that, no such order was passed. But that is the reason, in spite of me having the financial crisis.
That I understood. Please
Yes.
come to the merits of the matter.
Yes, Your Honor. I would like to take you through our the assets and liabilities which is filed by the petitioner.
What is the amount that is granted by the court?
Of the lower court, Your Honor?
10,000.
10,000, Your Honor.
Now, how much now you have paid now by way
Now
of
6,000 I have paid. It is apart from the the educational expenses of both the respondents. And this is apart from the educational expenses which
What the court has granted also.
Yes, Your Honor. Yes, Your Honor.
You have not questioned it.
Yes.
No, whatever it is, order of 10,000 is not questioned by you.
It is not questioned.
You are satisfied with that.
Yes.
Now, by way of an interim order, court had directed.
Yes.
Now, by way of an interim order, court had directed him to pay 6,000.
Yes,
and
Your
as per that, they have cleared everything.
Yes, Your Honor. As on July, it is cleared.
They were not paying the maintenance. In spite of this court has reduced, the maintenance paid was very irregular.
No, after the intermittent passed, we were cleared, Your Honor.
Mr. Counsel, please, both of you understand, we are not about allegations and counter allegations.
Yes, yes.
I've asked a simple question. Only simple answer I want. I said, as on today, all the amounts are paid or not? At 6,000. It is paid. The respondent is directed to pay monthly maintenance of 10,000 for the petition from date of filing of this IA. The petitioner also entitled for one-time litigation expenses of 10,000.
Initially.
Where do you get about this educational expenses?
No, we were separately, we proactively, since there's no.
No, we will not go into that.
Yes, yes.
Please restrict to this impugned order.
Sure, Your Honor.
So, please come. What is your income as of now?
My income as of now, as on date, is 47,000, Your Honor. With that, the loan which I'm doing it, I would like to refer you to the page number assets and liabilities which I filed. I filed the detailed EMIs which I'm paying on monthly basis. If you could refer the page number 49, Your Honor, on the assets and liabilities, I have made my loan details which I've taken based after the marriage, which now I'm still paying. Along with this, I also have the aged mother and also the unmarried brother. Even though he's earning, I should also able to help him with his marriage and the aged mother. And along with this, I'm also paying the educational expenses, Your Honor.
How much they're coming per year? That's what I wanted to know.
Sure, Your Honor. Educational now.
Do you accept the fact that he's paying that education expenses or not? Yes.
So it is actually miscommunication, Your Honor. Whatever the communication we
Both of you are not interested to argue the matter and at least
No, we are very much
apprise the
interested.
court of the facts, then I can't help. Because there are so many other matters which are
Sure,
pending.
Your Honor.
If both of you are ready to cooperate and answer? Yes. So what is the monthly, the school expenses so far he has paid? Page number? 1 minute. 1 minute. Around 1 lakh is paying towards the educational expenses.
when they mentioned in the petition, they are stated, they are paying 80,000 to 1 lakh each side. I point out that the commissions made by them in the petition. It's para 13. Para 13 of the petition.
So per month, it's coming to 12,000. Educational expenses are coming to 12,000.
It is apart from the one-time admission fee what we have
Annum
paid.
per annum, if it is 1 lakh, per month it will come to 12,000. Yes. So 12,000 and plus 10,000 towards the maintenance. So it's coming to 22,000. And
And
that I understand. Yes. So what is your income?
my income is 47,000 as on date now. With that 47,000, my lordship, I have to pay a monthly EMI of rupees 25,000, which one EMI which I could clear. The rest of the EMI including which I'm paying 25,000 and plus the insurance which I'm paying monthly 2,500 EMI and the aged mother I have to look after. And my food offer all the 3 dates. It is coming up to almost nearing to my salary, my lordship. Where that is also rent has been getting deducted. That no, it is a aged mother, your my lordship.
Children are dependent, right? So also dependent. She's a housewife that is admitted. In their objections, they admit that she's a housewife. She's not working in the work.
Yes. Both of you argue, I'll listen. I'm really not happy with the way these matters were going on. This matter on September 16th. They delete from part third. Yes, next.
Cell number 2, Shubha, a petitioner.
No, this court has asked you to file an affidavit to file. Have you filed? As per the order passed for this court, the land counsel, the respondent submits that, he'll come up with the affidavit, and then counsel, the appellant submits, petition submits that there's some inconvenience to the counsel for the petitioner. This is matter on 10th of September, and by that time, the respondent shall file an affidavit, or else the court will pass orders based on the material on record.
Super.
Whatever you want to do, you can do.
My lord, in the same month, can you give the time, my lord? In the same month.
Not possible. Yes.
For dismissal matters, serial number 3, yes, Dimaya.
Sorry, my lord, last occasion, though I was here, then all of a sudden my matter reached before the quota number 19.
Yes,
so
yes,
I could not be present on this.
Yes, yes.
My lord, this is the case. The petitioner herein is challenging the order passed by the Honorable Family Court
Page
on
number?
IA number 7 at page number 97, ma'am. The amendment application board
Page
on
number?
IA number 7 at page number 97, ma'am. The amendment application has been filed by the petitioner to amend this statement of objection, my lord.
1 minute, 97. You're for the wife or husband?
I am for the husband.
Who filed the petition? Husband.
Petition filed by the
Wife, my lord.
wife, my lord.
Is allowed.
No. Amendment application by me, that is the husband.
What I'm asking.
Yes, husband.
Is dismissed.
It has been rejected. Only on the ground that
What is the MC is filed on what ground?
cruelty ground, my lord. Statement of objection and thereby objected for the divorce on the sole ground that at any point of time there was no cruelty on the part of the respondent. But my lord, what has happened in the initial stages, the marriage took place during the year 2001, my lord, and the 2019 the respondent herein being the wife has filed a.
Before we go into all that, please come
Yes.
to the IA.
Yes, ma'am.
Support of the
Yes,
application
yes,
and
ma'am. Yes, ma'am.
order 6/17.
Yes, my lord. My lord, at page number 85, my lord.
We will look at page number 89.
80?
9.
Yes, ma'am.
89, yes. please
That is
read
affidavit.
Affidavit that we'll see.
Yes. Now, before that, my lords, I will read the application. I may be permitted to read the application page
This is the
number.
affidavit in support of the application.
Yes,
So first we'll read the affidavit.
affidavit, yes, ma'am. Para 2, my lords. I state that the petitioner herein has filed the above petition for the relief of divorce against me on the false ground of cruelty, and the allegation made against me are false, frivolous, and vexatious one. I further state that the petitioner herein has not come to this honorable court with clean hands, and as such the above petition is to be thrown out at the very threshold itself as not maintainable, since the entire petition, averment, contentions, and allegations are cock and bull stories only to make out a ground for divorce. Para 3. I state that after reading the entire petition, averment, contention, allegation, the petitioner herein which are made against me are utterly false. Divorce against the petitioner herein for her bad character, and she has been running a parallel family life with her own colleague, Mr. Rajesh Kundra, by ignoring and stopped cooking food for me, and not offered one glass of water, and not prepared coffee or tea for me. Since 2017-18, I have been taking food from outside even till today. However, I have been spending money on all the household things such as gas, electricity bill, telephone bill, maintenance of the apartment charges, daughter's school, college fee, tuition fee, and their all expenditures and other things. Though myself and petitioner are living in the same room along with the daughters, but not as husband and wife, and she is not treating me as her husband, but she is interested to live with her office colleague, Mr. Rajesh Kundra, and due to the same, she does not want to continue her marriage life with me. It is further relevant to submit that the petitioner herein has sought for the relief of permanent alimony from me, but the petitioner herein is not living with me as wife and not discharging her duty as a dutiful Hindu woman. She is not entitled for any alimony from me, since she is living illicit affair with her office colleague, Mr. Rajesh Kundra, and she is enjoying with him and touring with him and whatnot. That apart, the petitioner is one of the director of the company
Where
called.
is the original, your objections to the MC?
No, my lord. That is what my come out with the amendment application during the course of cross-examination, my lords. What has been.
No, I want to see your objections to the main petition.
Yes, my lords.
Where
That
are
is
they?
what the reason being is that though I have a doubt against the petition.
Those cannot be the grounds for
No.
amendment.
You
of
will also
petition.
kindly appreciate. No, one submission. Though
You should file your amendment should be in line with your original case.
yes,
What is your original case? Let's see.
what are my,
What is your original objections? Where are they?
yes, it is in the para
Page
Pa-
number?
page number 30 to urge, but I was not having any single paper to take my defense. Without having any documents, I could not take up that contention. How subsequent to the file, reducing of the evidence and during the course of cross-examination, you will also may kindly appreciate, I may be permitted to at annexes C at page number 62, my lord. 62, 63, and I may be permitted to read the cross-examination at page number 66 in the fifth line, my lord. 66, my lord. Shall I read, my lord?
No, please tell the court one
Yes.
single amendment in your main petition
Yes,
with regard to the character of the wife.
yes,
I said one single amendment in your objections
yes.
with regard to the character of
Character,
your.
I have
Where-
stated,
where
I have
did you
stated,
say?
I have stated, I have stated.
Let us.
It is stated, my lord.
Yes.
It is stated, my lord. But with whatever I have stated in my amended petition, that has not been stated with specifically state. Yeah,
I said,
yes,
what
it is stated. I have
what it
stated,
is
my
about
lord.
her
I have
character?
stated, I have stated. Used to say that is- First I denied, yes, my lords, regard 53, my lords.
Yes.
Regarding para 9, 53, for the 32, para 32, my lords. It is true that the petitioner had taken up a job in the private company called IDEB Project Limited, Wellness India Limited, Century Real Estate Housing, so and so and so, and drawing a salary rupees 1,60,000. Afterwards, she started the company along with her old colleagues in the name and style I Assist Advisory Private Limited, and she is one of the director of the company along with other directors by name Rajesh Kundra and Shivani Kundra, company incorporated on 15/6/2017. But the company address is mentioned as the house address of the respondent, but the petitioner herein has not disclosed the same thing to the respondent herein. At any point of time, the respondent
How does
herein,
it say, how can you say that it is with regard to her character?
pardon my,
It is not referring to her character.
no, it is stated, my lord, it is stated.
Then you please look at it and come back. We can't wait for you to read
No,
now.
my lord, before
Just
that,
pass
my lord,
over,
I may be,
pass over. Yes,
Number 4.
my lord, pass over, my lord.
pass over.
My lord, instead
Yes.
of that, kindly have tomorrow, tomorrow.
Any interim order in this?
Earlier,
My lord, I have a submission with respect to this one. My lords, actually, this honorable.
I'm asking, is there any
my
interim
lord,
order?
No,
my
my
lord,
lord.
I
No,
will
my
make-
lord, there is a
there are-
stay of the impugned order, but they have given an memo before the Honorable High Court, Honorable Family Court, stating that there is a stay of the entire
lord,
proceedings before
yes,
the Family
yes,
Court.
definitely.
It
My
was
lords,
being taken for 1 year.
my lords, one
So they
submission.
got the knowledge that there is
My
no
lord,
any stay of
what
the
has happened,
proceedings.
your lords may kindly
They-
appreciate.
Please let me make the submission, sir.
I will also make
Please
submission.
let me allow.
The petitioner to serve the learned counsel so and so. Till such time, there shall be an interim order of stay of the impugned order dated in I number 7. So it's an order, impugned order is stayed.
Order is stayed, my lord, but the memo which is being given before the Honorable Family Court is regarding the stay of the proceedings, entire proceedings.
My lords, once,
Please.
let me.
I will hear
Yes,
you, I
yes,
will hear
yes.
you. Advocate for respondent filed memo dated 2/12/2023 with copy of one document reporting filing of WP before the Honorable High Court of
Next to that
Karnataka,
hearing date, my lord.
so and so. Filed memo dated reporting that the further proceedings of this case is stayed with the Honorable High Court of Karnataka. How they are stayed?
My lord.
Further, my lord.
One submission, my lord, one submission. My lord, this is what I stated. After that, my lords, I'm not making any false submission. Heard directed to serve copy of the writ petition to the counsel who is appearing for the respondent before the trial court. Interim order as prayed for. And my lord, Lordship Justice M. Nagaprasanna has passed an order. Not only, and open court it has stated, my lord, is all the further proceedings and all. Based on that time, and I got the order subsequent later, that is what.
My lords,
While
even
filing
if
the objection to the made it very.
Order, you have made a submission before the court
Yes,
on
yes.
14/12/2023.
That is
When
what,
is
my
this
lord.
order uploaded?
My lords,
When is this order uploaded?
that has been, we got the order subsequent after filing.
on 22nd,
memo,
they
my
have
lord.
taken the
After filing of
certified
the
copy,
memo,
my
my
lords.
lord.
Please come. In this case, on 12/12/2023, an order is passed whereby the court had granted stay of the impugned order dated 2/11/2023. It is the case of the counsel for the respondent that it is informed to the court that there is a stay granted by this court. It is made clear that only the impugned order is stayed and the court is at liberty to proceed with the matter.
Reply to that, my lord. I'm not the person to making any wrong submission.
Yes,
Sometimes
yes.
what will happen, my lord, in one of the matter, my lord, no, sorry to disturb.
Counsel, I
Because
understand what you
throughout my
Please.
profession, I have not made any wrong submission or filed any.
Learned counsel
In some
appearing
of
for
the
the
cases-
petitioner submits that the order that is passed in the court, he understood it as stay of all further proceedings and submitted before the court. Yes, next.
Till number 4 for orders matters. Till number 4, Balakrishna K.
I represent that.
Rajeshwari.
The apex court has passed the order. I'm passing. The petitioner filed visitation rights before Andhra Pradesh court. Same was challenged by the respondent before High Court of Andhra Pradesh. Then Supreme Court also they filed. It was given the order in favor of the petitioner for visitation rights. And there is a direction also to consider the visitation rights if any disturbance is there. Then
What is the impugned before this court?
the impugned before this court, the respondent filed the GMCPC before family court, and I have filed the application for the visitation rights. The honorable family court has rejected. Then I have filed a petition.
So nothing remains in this now, because you already have a visitation from the court and which is confirmed by the apex court. That is now he doesn't want his writ petition to be heard now in the light of the orders passed by the apex court. You can't have any difficulty with this. Yes, please come. The present writ petition is filed, questioning the order passed in I number 10 NGA and WC number 101 of 2018, whereby the court had dismissed the application filed by the Honorable Apex Court, had passed an order permitting the father to come to Bangalore to exercise the visitation on every Sunday.
Family court mediation center.
The first 4 meetings shall take place on every Sunday at Bangalore Family Court premises under the supervision of a mediator without the presence of either the grandparents or anyone representing the grandparents. The family court shall see to it and will decide whether the further sessions after the first 4 need to be carried out in the same manner or a change is required. By 4 p.m. after the meeting, the child will be handed over to his grandparents. The concerned registrar is directed to communicate the order to the concerned family court of Bangalore for onward complaints. Then counsel for the petitioner submits that the order, they have assigned the order passed by the family court, passed by the High Court of Andhra Pradesh.
Yes, and Supreme Court upheld.
And the same was carried to the Supreme Court, and the Supreme Court has passed this order dated 10/4/2025. As such, nothing as is already the court has granted the visitation. Nothing survives in this petition. Accordingly, in the light of the order passed in SLP number 12294 of 2025, this writ petition is disposed of.
Please.
Yes, next.
Serial number 5 for orders matter. Ajimuddin M. Mohit Khan.
Appear for the petitioner, my lord.
R3 is not represented by the mother R1.
No, my lord. R3 is intentionally avoiding to take the notice, my lord. She is
R3
residing in
or
the same address where R2 resides, my lord.
R2 and R3 are minors represented by R1. Where will the minor, and your mother is there to represent them? Why notice is
Notice
necessary?
to R1 has been served,
Sir.
my lord. It is held sufficient.
The present RPFC is filed, agreed with the orders passed in I number 2 in criminal miscellaneous number 84 of 2024, dated 23rd October 2024. The office has taken the objection with regard to the maintainability in view of section 19(4) of the Family Court Act, as the present RPFC is filed against an interim order. The office objection as raised or sustained, and the RPFC is dismissed, giving liberty to the petitioner to file an appropriate petition within a week. Yes, registry is directed to return all the documents.
7.
I appear for the petitioner, my lords. That's the impugned order is in page 36, my lords. I am the father-in-law of the respondent number 1. 36, my lords. Summons was issued in the family court with regard to certain documents of respondent number 2. I have appeared before the court, my lords, stating that I do not have the same.
First of all, you have to answer what is the maintainability issue.
Yes, my
against an interlocutory order, you have to file a writ petition.
Property has been attached, my lords, without their assigning any reason, my lords.
Where is that?
My lords, that my lords would find it at page 37, my lords.
In criminal miscellaneous.
Yes, my lords.
30?
37, my lords. I have appeared and said I do not have the documents. Without there being any reasonableness, my lords, my property is attached.
Convert this petition and file a writ petition. Will come to a writ petition.
Given for 3 to 4 days time, my lords, I will comply. I'm
You
sorry.
can do it anytime. Court has no urgency. If you have urgency, you have to do it.
I will do it immediately.
Within 1 week.
Sure, ma'am.
Once the same is converted into a writ petition,
Yes, ma'am.
list the matter.
Sale number
Grateful,
three.
ma'am. Great.
As
For
I
all,
have
for
made-
the statistic purpose, it is disposed of. Yes, next.
Sale number
Daughter of the respondent. My lord, I filed a petition for enhancement, my lord. On the last date of hearing, the respondent was directed to file his affidavit of assets and liabilities. It's not, he hasn't come on record, my lord. I may be
Respondent has
adverse.
appeared last time.
No, my lord. I1 came to be allowed.
I number 1024 is filed with the petitioner seeking direction to respondent to file his affidavit of assets and liabilities. Accordingly, is allowed. Now, what will happen now?
Adverse inference may be taken and I may be permitted to argue my matter on merits, my lord.
What is this? What is the impugned order?
40,000 a month was granted, my lord. I appear for the daughter of the
Where is the
respondent.
impugned order?
It is at page 24, my lord.
24?
The
I think there
reason,
is another volume.
volume 1, my lord.
Page number 24.
24, the reasons are at page 28, my lord.
Yes.
If I may be permitted to read, my lord.
Partly allowed. The respondent is hereby directed to pay rupees 40,000 per month for the maintenance of the minor children from the date of application till disposal. What is your income?
My income is 2.8, my lord. The income of the respondent in his affidavit of assets and liabilities before the trial court, he's mentioned 4.96 base pay, my lord. 4.87, apologies, my lord. 4.87 base pay, page 54, my lord. At page 50,
Expenses of the child. Come to that. Therapy of so and so. Physiotherapy 21,000. Speech therapy 16,000. Food therapy 14,000. Ayurvedic treatment. So you're spending an amount of rupees 95,100.
the total amount that I spend, that the mother spends on the child is about
Plus 8,000. Total, we take it as 1 lakh. You're spending 1 lakh towards the child's
No.
expenditure.
No, my lord, it works up on an average, it works up to 2.5 lakhs, my lord.
Per annum.
That's just the
No,
therapy. Yes,
that's what
my,
I'm
yes,
saying.
my lord.
There are certain expenditures which are monthly, certain expenditures yearly.
Yearly, yes, my lord.
So after point number 5, stated or about 2,80,500 is your annually, isn't it?
Yes, my lord.
So
My lord, in my affidavit of assets and liabilities
one
beginning,
minute. So precisely it is 33,660 per month. Then your monthly expenditure according to you towards the child for about 95,100.
my lord, what you're referring to is just the therapy, my lord, at page 48, beginning at page 48 to 49, I mentioned the detailed expense of the child, my lord. Page 48 and 49 contains the detailed expense of the child.
Hmm. Fruit, vegetables, dairy products, gas, electricity. Home repairs from plumber, electrician. How can you show in the
Those are
dependents
general
account?
expenses.
We can't show them, show on the dependents expenditure. What is the age of the child?
9, my lord. The petition was filed when the child was 2. Therapy, education, medical expenses are substantial, my lord.
Now please come to his statement of assets and liabilities.
His affidavit of assets and liabilities is at page 584, my lord.
In the other volume?
Yes, my lord.
$584.
584, my lord. Annexure H, 584.
What he stated, what is his income?
He at page number 596, 87 lakhs, my lord. This is his base pay, not his CTC.
Where
my
do you
lord.
get that?
At page 596, my lord, of his own affidavit of assets and liabilities.
596. Spending amount of rupees 1,28,760. And another 10,000 if you take for other expenses, 10,000 and plus 13,000, that is 23,000. It comes to 1,50,000 roundabout. Then and where are his expenses?
He has mentioned his at page 585, my lord.
585. Yes.
Groceries 30,000, fruits 8,000, vegetables 9, dairy 9, gas 2.
Altogether, come to the
Altogether, he's mentioned that
16,085. What is this?
7,64,800 a month and 16,85,436 a year. He says his monthly expenses are almost 8 lakhs. My lord, if I may.
Please come. The present writ petition is filed. Agreed with orders passed in. I number 3, in criminal miscellaneous number 36 of 2019, dated 15th June 2024, whereby the court had granted 40,000 as maintenance to the child. The mother is before this court seeking enhancement of the maintenance amount. The mother representing the son has filed this application, filed the IA number 3 to pay an amount of rupees 2 lakh per month. Is diagnosed with skin related issues when she was aged 2 months and also diagnosed with autism, and the child has to undergo several therapies. As per the statement of assets and liabilities filed by the wife, her income is 2 lakh. How much is her income? 2 lakh?
2.99, my lord.
2 lakh. Where do you get that? Page number?
In my affidavit of assets and liabilities.
That's what, where it is. The 2,96,000 per month. And it is stated that towards the child, for physiotherapy, she is spending an amount of rupees 21,000, speech therapy 16,000, food therapy 14,400, Ayurvedic treatment 8,400, therapy transport 12,800, music class 500, assistant teacher 22,000. All comes to 95,100. And towards her school expenses per annum, she's spending an amount of rupees 2,80,500. And she requires a help at home as she's working, and she's paying an amount of rupees. Where do you get that one? I saw somewhere.
Nanny and house help is 13,000, my
Where
lord.
do you
It's
get
under
that?
general expense.
Page number?
49, my lord.
Before the court, before the family court, has filed a statement of assets and liabilities. In that, he has stated that his assets, his monthly expenses are
Page 588, my lord.
7,64,800 per month, and yearly it is 16 lakhs. Yearly expenses are 16,85,436. In that, he has shown an amount of rupees, he's spending an amount of rupees 13,200 towards per annum towards a mobile phone for the mother, 12,750 to the mobile phone of the father, and physiotherapy for the father 11,000. Part-time caretaker for the father 25,000. Physiotherapy for the mother 21,000. Full-time caretaker for the mother 24,000. And also parents trip to religious places 9,600 per month. Parents meeting family in Mysore attending social events 4,500 per month. Restaurants at work, home food delivery rupees 7,500. And according as per his own statement of assets, and liabilities. His income is
Page 596, my lord.
is 4 is working as a director, product management, and his monthly income is 4.8, age of the child, present cost of living, medical and other expenses. Guesswork has to be made to determine the quantum of maintenance to be contributed by the father for the maintenance of the child. Since both the parents of the minor are employed and having handsome salary, both of them shall support the child. Even if there is little more or less in the financial assistance of the other. And admittedly, the child is under the care and custody of the mother. And excluding the school timings, the child needs to be under the constant supervision of an attendant to take care of the child. And as long as the child stays at home, since the mother of the child is also employed, she is bound to avail the service of an attendant for not less than 8 to 10 hours in a day. The attendant must be skilled and capable of handling the child, having health issues, and to attend the needs of the child, keeping in medical instructions, if any, in handling the child. And accordingly granted 40,000. And counsel for the petitioner submitted that when the father is earning nearly 5 lakhs a month, and half of it is the salary of the mother and the requirements of the child, court has failed to consider basing on their income, there should be a proportionate contribution to the child. It is submitted that the statement of assets and liabilities that are filed before the court are not or do not disclose and conform to the law laid down by the apex court in Rajneesh versus Neha. As such, in this case, they've already filed an IA seeking a direction to the respondent to file his statement of assets and liabilities. It is submitted that the same is not filed. This court, where is the order sheet? Order sheet. On 1/2/2025, has permitted the counsel for the petitioner to take out notice on the respondent, to take notice to the respondent by all modes of communication, alternatively to the counsel representing the respondent in the proceeding before the family court. Then on 36/2025, another order is filed about service of notice of hand summons to the learned counsel appearing to the respondent before the trial court, clearly mentioning the name of the counsel. Where is that IA? Where is it held sufficient? No. Where is that memo? Where is it served on the council?
On 15/7/2025, we have.
Where is that memo?
This is the office copy.
Take that. As per the earlier order, they have served on the party and filed a memo. And another affidavit is filed. That on 14/7/2025, hand summons along with the copy of the petition was duly served upon the trial court counsel at his office.
SH Razvi, my lord.
That's what I
Mention
repeatedly
it in
said.
the-
In spite of that, you are not complying with the said order. Even on the last time also, I said you file a memo indicating the name of the. Right. SAH Rajvi. And as such, the notice is the police served on the respondents and there is no wakalat is filed. It appears that the respondent is not interested to pursue the matter. Hence, this court has, as a notice is served, is proceeding with the matter. Next, having heard the length answer the petitioner, there is the material on record. The therapy expenses per month are about 33,700 approximately. Then the annual expenditure towards the school and others is coming to 95,000. What is the annual expenses of the school?
My lord, the education expenses, school alone is 2,15,000.
2,15,000. Give that
My lord,
first volume. The
page 49, my lord.
the
My lord, the child requires a shadow teacher. So an assistant teacher, shadow teachers with her all the
that's
time.
what I'm looking at it only. I'm asking the therapy. The therapy and the medicines are coming to an amount of rupees 1,03,100, and apart from that, she requires a nanny.
Page 48, 49 and 50 is consolidated.
No, 48.
Yes, my lord.
And 48, you tell about all the house expenses which the girl is unconnected with. So she requires a nanny and house help. That is her in that entire page of 48 and 49. That is only what she is concerned with.
General expenses, nanny and
No,
house.
you say car
Therapy.
fuel. No, car fuel here 4,000 you will show, and again in her expenses you show transportation.
Because she has to go for 4-5 therapies,
But you
my lord.
cannot add everything at every place. If you are adding fuel, car fuel, transportation at one place, again you can't add transportation at another
If I may
place.
explain, my lord, sometimes the mother picks and drops the child up. Sometimes she gets an auto to pick the child up from therapy because she's at work. So the transportation expenses are different, my lord. It's all calculated on actuals and the bank statements have been produced, my lord. In my evidentiary affidavit, I've in detail produced everything.
School expenses are 2,15,000
per year. Assistant teacher is 22,000 per month, who's a shadow teacher.
No, when you speak about the school expenses, that is all to
Be in school, my lord.
In
The
school,
shadow teacher.
it includes everything.
No, my lord, that is a school fees, my lord. 2,15,000 is the school fees. Assistant teachers should be paid every month. A shadow teacher should be paid every month 22,000. It's under education expenses at page 49, my lord.
No, but don't you feel that all these are all exorbitant figures?
This is how much is paid on actuals, my lord.
Then
A
where are
shadow
the receipts
teacher,
for this?
we have my evidentiary affidavit. I may
No,
be
if every autism kid, he requires this much of amount, is it?
because of the child.
Third, the difficulty is for the purpose of having maintenance, these kind of figures cannot be, you can't project this kind of a case, which nobody can believe.
My lord, the shadow teacher is with the child the whole time. Since she's suffering from autism, she cannot understand what the normal teacher says. So she needs a shadow teacher with her all the time. That shadow teacher charges. She's
Not about, don't only mention about the shadow teacher. What are all the expenses you have mentioned every month? It is all exorbitant figures as it appears.
My lord, the expenses are for her therapies,
So
for her education.
No, you like 2,90,000. You spend 2 lakh and odd on the child per month.
My lord, the mother can't be faulted for wanting the child to live a normal life like the other children when
that's
she's
not
suffering
the argument.
from.
That's not the argument. Argument is when you're spending when you're getting an amount of rupees 2,90,000, how can, if you're all are taken, it comes to 2,50,000 a month for the child alone.
if we exclude the groceries and the expenses, yes, it comes up to 2,50,000.
50,000.
Annual expenses are also there, my lord, 7,47,000. Some payments are made annually, some payments are made per month.
No, even if all of this taken, annual payments are taken on a monthly basis, on a percentage.
average.
That also you're showing it 2,50,000.
That's how much it takes to take care of a child suffering who's in a spectrum, my lord.
The mother has given the figures showing almost 2 lakhs and lot that she's spending towards the child and sought for the maintenance. This court has perused the expenditure as stated before the court, and it appears that some of the amounts that were stated are exorbitant, and the court cannot, considering the social status of both the parties and the income of the parties, even this court feels that an amount of rupees 1 lakh towards the expenses of the child, considering the income of both the parties, would be an appropriate amount. Accordingly, the petition is disposed of, granting maintenance of an amount of rupees 1 lakh. Yes, ma'am.
My lord, if I may, my lord had mentioned minor son, that may be changed to minor daughter, my lord. And my lord has mentioned the child suffers from eczema and autism spectrum disorder, my lord.
Does
Line
already
two.
have been? Yes.
Obliged.
Hearing on interclass application, serial number 9, should be ready at.
What is this?
Your Lordships, Your Lordships kindly have page number 10, cause title of the.
This order is passed
This
on 5th
on-
of September 2024.
Yes, Your Lordship.
Yes.
Notice was not served, not ordered in
Let's
that
see
appeal.
that. Let us see.
I have produced the entire order sheet also of that appeal, Your Lordships, at page 25. The respondent number two herein, and he had appeared, the respondent number 2 alone had appeared.
Your respondent number
3,
and in the original suit,
defendant number 3.
defendant number
Three.
3. Where is the,
And he, the respondent number,
where is the record? No, the earlier order should be there, earlier bundle should be there. No, to MFA number so and so. This is matter on 2nd of September. Yes.
Serial number 10. Serial number 10. Hanuman Sarai
There is a
Pakke.
delay of 480, 1 decimal delay is there.
I number 1 of 25. What is the reason for the delay?
And in the first instance, my lord, the respondent filed the miscellaneous petition before the Sidlighatta court. After dismissal of that,
File. Where is the idea? Hmm.
in the first instance, my lord, she filed the Sidlighatta court, JMFC court. my lord. The same is a dismissal for non-prosecution without mentioning that one. my lord. Subsequently, second petition is also filed before the Chikballapur court. my lord. After lapse of 5 years, my lord. And this order is came to be passed, ex parte order, my lord. Page number 9, my lord.
Please come to the order passed by the family court. If you don't appear, the court will set you ex parte. What is the, if you are not appeared before the court will set you ex parte.
No, that she is not revoked that order, my lord.
Which order?
The earlier order, my lord, Sidlighatta order.
That she will, that is a different aspect.
No.
You are given notice in this. In criminal miscellaneous 33 of 2023, were you served with a notice or not?
Not served, my lord.
Why did you not appear? If you don't appear, court has passed an ex parte order.
The notice was served, my lord. In the first instance,
Will not go to the first instance. This order is passed on 18th November 2023.
Yes, madam.
Then criminal miscellaneous of in 33 of 2023, earlier petition filed that you have not chosen to.
Madam, in this,
Even after the order is passed, you keep quiet for more than a year and come before the court and say,
madam, in the first answer, she is filed there in the Sidligata court. madam. The first
I
125
understand
is
that
filed, madam.
she filed a petition.
After lapse of 4-5 years, my lord.
Let it be how many years lapse.
This-
But she has filed, you are served with a notice, you kept quiet. You don't even explain what is the reason for the delay
Madam,
from 18th November 2023 till now.
The evidence is not tendered, madam. She is given it evidence, madam. For second time also,
I am
she
not
is
on
not,
that point.
for
Please understand.
cross examination, she is not
You have
tendered.
already understood what is my question. You have to answer only to that. I said, when you file an application under Section 5 of the Limitation Act, you have to give the reasons for the delay. The reasons that are given in this affidavit are not convincing. Once they are not convincing, we will not go into the merits of the matter at all.
Madam. Kindly pass over, madam.
Passover. Next.
11. Nehru MN. Number 11.
In this case, in this case, I am for the petition.
You want to withdraw the amount?
No, your lordship. She is living in adultery, my lord. And apart from that, it is an ex parte order. At the time of availing the order, my lord, she has stated before the court stating that two daughters. Apart from that, my she is living with the adultery and she's one Sanjay Babu with the paramour. The paramour, against the paramour, the complaint has been lodged against the POSCO. My daughter has lodged a complaint against him. The criminal case is there. 164 statement is there. 161 statement is there. And that the paramour's husband, wife has lodged a complaint against that. They have got an illicit relationship. That all suppressed. So I may be permitted to address the argument. That's all.
Where is the impugned order?
Page number 60, my lord.
Why did you not contest it?
So initially I was present, my lord. In the year of 2020, I got a medical problem with suffering from COVID, my lord. Thereafter, I am not able to. Immediately after that, I appeared and filed objections also.
Where
By
is
the-
the order?
Order is 60, my lord. The typed version is page number 71, my lord.
This IA is filed in the MC.
In MC, my lord. Even this honorable court can fix the date also. I am ready to argue the matter before the lower court, my lord, by producing all the documents.
My lord, copy is not served. I need a copy of copy.
What copy? You have already filed a petition to withdraw the amount that you can file without a copy.
No, as per the instructions, senior, my lord.
So how many?
Next Tuesday, this is matter on next Tuesday, will pass orders finally, and the counsel for the petition shall serve the copy of the petition on the counsel for the respondent. Yes, next.
Number 12. Nayanthara BG.
Respondent in this matter. As I appear for the respondent in this matter, the application before this court is filed by me. In July 2024, about a year back, my lords, there was a judgment passed by this honorable court wherein it was recorded that both the parties had agreed.
Passover, yes.
Okay.
What's his permission?
Yes, we'll see, not now. And the matter reaches that you can say. In the 13th, memo is filed stating that in the matter, the disputes between the parties are settled before the trial court, that is MC number 11 of 2022 and also criminal miscellaneous number 83 of 2022. Hence, the petitioner do not want to pursue the matter. Accordingly, memo is taken on record and dismissed as withdrawn. Any signatures? No?
ಬೇಜಾರಾಗ್ ಕೂತಾಗ ಫೋನ್ ಮಾಡಿದ್ರಿ ಸರ್ ನೀವು. ಬೇಜಾರಾಗ್ ಕೂತಾಗ ಫೋನ್ ಮಾಡಿದ್ರಿ ನೀವು ಇವತ್ತು ಅಂತ.
ಹೌದಾ? ಯಾಕಪ್ಪ?
ಆಫೀಸ್ ಸರ್.
ಎಲ್ಲ ತಲೆ ಕೆಡ್ಸ್ಕೊಂಬಾರ್ದು ಏನಾದ್ರು. ಈ ಕಡೆ ಕೇಳಿ ಈ ಕಡೆ ಬಿಡ್ಬೇಕು.
ಹೆಂಗಾನ ಆಗಿರ್ಲಿ ಎಷ್ಟ್ ಮಾಡ್ಕೊಟ್ರು ನಾವ್ ಆ ಡೆಸಿಗ್ನೇಷನ್ ಅಲ್ಲಿ ಇದೀವಿ ಅಂತಂದ್ರೆ ಅವ್ರು ಮಾತಾಡೋ ಮಾತೇ ಡಿಫ್ರೆಂಟ್ ಆಗಿರುತ್ತೆ ಸರ್. ಆ ಮಾತ್ ಕೇಳ್ಸ್ಕೊಂಡ್ ಬೇಜಾರಾಗ್ ಕೂತಿದ್ದೆ, ನೀವ್ ಕರೆಕ್ಟ್ ಆಗಿ ಅದೇ ಟೈಮ್ ಫೋನ್
ನೀನ್ ಬಿಟ್ಟು ಯಾರು ಊಟ ಮಾಡೋದು?
ಇದ್ದೆ. ನೋಡಿ ಹಿಂಗ ಆಯ್ತು ಅಂತ ನಾನು ನಮ್ಮ ಮನೆಯವ್ರಿಗೆ ಹೇಳ್ತಾ ಇದ್ದೆ. ನೀವ್ ಫೋನ್ ಮಾಡ್ತೀರ ನಾನು ಅವ್ರ ಜೊತೆನೆ ಮಾತಾಡ್ತಿದ್ದೆ.
ತಲೆ ಕೆಡ್ಸ್ಕೊಂಬೇಡ. ಹ್ಮ್
Memo is first stating that the petitioner is not entitled to pursue this matter and is paying the residence to the memo is taken on the court and the petitioner is dismissed.
Passover matters. Passover matters in list 1. Serial number 4. Serial number 16. Not 4. 16. 16 Sachin BS.
For the appellant, my lords, not, both the counsels are not present. I tried to call him, my lords, but I'll inform him again, matter could.
After the district court final hearing, MFA 2019. The morning there is a representation on behalf of the counsel for the appellant, but no representation on behalf of the respondent insurance company. While the insurance companies are representing the matters of 2019 are not known, when ultimately it's for the insurance company to pay the amount and also interest. It's very unfortunate. This is matter finally on 3rd of September, on the day, even if there is no representation on behalf of the insurance company, the matters will be heard and orders will be passed. Yes.
Serial number 23. Shantraj K. D. Vijay Kumar.
What is this 30?
23.
In the morning, there is no representation. Matter is passed over. Even in the afternoon, also there is no representation on behalf of the appellant. This is matter for discussion on 11th of September. Yes.
Serial number 25. A. M. Venkatesh.
I am for the appellant, my lord. As discussed in the morning, my lord, it may order may be passed. My lord.
Then, dated 28 January 2022, the insurance company whose report is called on one is on the ground of liability and the other is on the ground of planning also. And on the ground of
Quantum.
contempt. It is the claim petition is filed under section 166 of the MVI seeking compensation of an amount of rupees 5,05,000 along with interest at 10% per annum. It's a case of the claimant that is a minor and sliding third standard. On 25/12/2008, at about 4:30 p.m., when the claimant and his father were traveling
Or walking on the road.
walking on the left side of the road, the driver of the auto rickshaw drove the same in a rash and negligent manner and dashed the petitioner, dashed the claimant, and he had sustained injuries. And as per the evidence of the doctor, he had sustained 50% disability. The court had granted compensation of an amount of 8,15,080. And the head of pain and suffering 50,000, medical expenses 1,90,000, and for academic and distinguished status 33,000, future medical expenses 1,000, altogether loss of future income 5,44,320.
No permit to place the vehicle on the.
As there is a valid policy, the court has held that the insurance company is like permit is renewed up to 2013 has to proceed from exhibit asked by itself. It has to be held that there is valid permit. Therefore, it has to be held that the insurance company has paid to the auto rickshaw in question had no valid permit. What is this wrong? Basing on what you're saying?
R6, my lord. Yeah, permit only up to.
When did the accident happen?
24.
Take out R6.
1 minute.
R5.
My lord, yeah, permit only up to 17/1/2019. 1 minute. For the morning. But he has applied for the permit after the accident.
Exhibit R place.
17/1. What dwara one mother?
Yes.
R6, my lord, R4, my lord, you will ask me condition.
Date of expiry. 8/10/2003 to 7/10/2008.
Yes.
And renewed up to 7/10/2013.
Yes.
What is the date of accident?
Date of accident is
25? 2008. Then,
more than 1 month afterwards, she has applied for the renewal.
where do you get that?
Check there. My dad had only temporary registration which was valid for 1 month. And I was applied for the permit, which the other vehicle, he had 2 vehicles. One vehicle had permit, one other vehicle has no permit. He has got he has got.
Now, you say, as with the date of accident had taken place, there is no permit.
Yes.
But the exhibit R5.
Yes, ma'am.
And the order of the court says something else. So what is the document? What are the exhibits that are marked on your behalf to show that as on that day there is no permit apart from exhibit R5?
R5, my lord. Exhibit R4 will not my stream. R4. That my other colleague has prepared it. Huh? R6 only.
R1 is a copy of policy, R2 endorsement.
Well, R6 madam.
R5 permit. Exhibit P6 that is.
Yes, P6. Yes. 17/1 2009 yes, applied for the renewal.
R6 is considered P6, I think. You look it up. Particulars of previous registrations. Date of registration, 7/1/2092. Look at the
Shivanagoda has not come.
Morning he argued.
Morning he
Ask
argued.
him to come. We clarify this. That's the only thing yet now. As far as this is concerned, based on what he submits, I'll pass orders. I'll complete the remaining order.
My God, we lots to be kindly have it tomorrow, madam.
Not possible. Every day I get the court can't do this.
Tomorrow morning, madam. Because I think he has gone back.
Sometimes.
Mane ಹೋಗ್ತೀನಿ sir. He has gone, said he is going back. Therefore, kindly have it tomorrow.
As far as this pay recovery is concerned, anyway, you are not concerned with this. So that it will come tomorrow. Remaining order will be given.
Yes, yes.
Sorry. When counsel appearing to the insurance companies of this as on today, the accident has happened. The vehicle was not having a permit. That permit was taken or paid. As such, as per the law laid down by the ethics court in
Rani's case and Namrutpal's case.
In Rani and others versus Nation Insurance Company Limited and others reported in AR Online 2018 SC 84. The insurance company is liable to insurance the principle of paying recover will apply, which the court has tried to consider. Then coming to the compensation, when counsel submits when counsel for the insurance company submits when the boy is a minor and he has suffered 3% disability, the court applied the law laid down in
Master Mallikarjun case.
In Master Mallikarjun's case, reported in 2014 SCC 396. It is submitted that the court had considered this like any other in case of a major working person, and the court ought not to have
Applied multiplier system.
It's and they consider the future loss of income, which is contrary to the law, they don't get apex court in Master Mallikarjun's case. Then counsel has particularly relied on paragraph number 12 of the order. Next paragraph, when counsel appealed to the respondent submits that this is the second round of litigation. Earlier, the court has remanded the matter, and after the remand, the court had considered all the aspects and it granted the compensation. It is submitted that there are no grounds to interfere. Next paragraph, and under the counsels, there is nothing on the court. This is a case where the minor is injured, who is studying third class.
Yes, but start.
Who is studying third class. And the Honorable Ethics Court in Master Mallikarjun of the Patient Insurance Company Limited has laid down the law how the computation of compensation has to be. And it is held by the Apex Court that the appropriate compensation on all the heads, in addition to the actual expenditure for treatment attendance, should be, if the disability is about 10%, up to 30% to the whole body, rupees 3 lakhs, up to 60%, rupees 4 lakhs, and up to 90%, rupees 5 lakhs, and above 90%, it should be rupees 6 lakhs. For permanent disability up to 10%, it should be rupees 1 lakh. And the court is also, apart from that in this case, the disability that is sustained by the claimant is 15%. Then at the head of pain and suffering, already undergone and to be suffered in future, 500. For 5 months, it comes to 22,500. The medical expenses that are spent for the claimant are an amount of rupees 1,91,560. Attendant and other benefits, as it is there in the hospital, for how many days?
21 days.
The
21.
court had granted 33,000, and this court is not inclined to interfere. Accordingly, the claimant is entitled for an amount of rupees 5,47,060. Accordingly, the compensation is reduced from 8,19,880 to 5,47,060. When it comes to the liability of the insurance company.
It is page 21, page 41. Para 40, page 21, it is there, madam. That regarding the liability.
It is there. You said tomorrow Shivanagowda would come and.
But now my colleague has been able to find out.
Yes.
The Honorable Court in para number 12 of the judgment has held that the defense that the Honorable Court in para number 12 of the judgment has held that the defense that the vehicle had no registration at the time of accident is not available to the insurance company. The respondent number 2 has contended.
That's against insurance company that's finding.
My lord, further it is said he has applied for the.
Tomorrow, the discuss as judgment dictation as item number 1. Yes, yes. Keep this Rani also. Yes, yes.
10, which number 2, serial number 10. Which 2, serial number 10.
Yes, Mr. Counsel.
And also produced only 2 documents. On the basis of the 2 documents, the learned judge passed an order.
Unless now this you have come to the court, I can understand if you have come one time. You have come to the court with a delay of 481 days.
But
First of all, step 1.
that is
we will not go into the
earlier Sidlagata court she filed, my lord. After dismissal of that case, my lord, with suppressing that, my lord, once again she filed the in Ballapur, my lord. There also, my lord, without I appeared enter, so thereafter within one kindly look into the order sheet, madam. Order sheet, madam.
Yes, I will look into, I will consider and I'll pass orders. I will dismiss this idea.
Kindly look into one set.
I'm saying I'll accept whatever you say, that you appeared for 2 times. After that, you didn't appear. Court has passed an ex parte order. That is passed in the year 23. You were questioning it in the year 25 with a delay of
481
481
days.
days. When you file an IA under Section 5 of the
Affidavit.
Litigation Act, you have to give the reasons. What are the reasons?
That is the reason.
Yes, give that. Please come. The present RPFC is filed with a delay of
Madam.
481 days. We can't, you can't, as a matter of course, you can't come to the court. That's why I gave you an opportunity in the morning. The RPFC
Madam,
is
kindly
filed.
pass on. My colleague is.
This matter, I'm filing the, I'm filing the objections to the IA. I've already served it on my learned friend. Now, my lord, giving more time will not serve its
So then
purpose.
what should follow?
Please, my lord, my humble suggestion is this. The wife and the children are living in the house. They're there from the last 4 years. So far, he has given about 32 lakhs towards EMI. Irrespective of the market value of the house, his contribution to the house as of today is the EMI amount of 32 lakhs. I have paid a bulk of the EMI. I've expended nearly up to 80 to 90 lakhs on the EMI amount. Because I'm willing to take on the loan, pay all the EMIs.
He must have
and
contributed something.
Return his 35 lakhs
No.
investment.
Apart from paying the EMI, the bank will not give the 100% loan. He must have contributed
No,
something.
he's contributed on his down payment and EMI together adds up only up to about 32.
Is it so?
My lords, it's about 48 lakhs is my understanding, the total of the down payment, EMI, and some maintenance amounts that he has paid towards this. No, not maintenance towards the society, my lords, for the association with respect to the property, not the interim maintenance. I'm not talking about that at all.
Not
So,
extra maintenance.
no, not that.
When you're living there, you pay maintenance. You can't.
Correct.
In that.
My lords, for the period where I paid after I was thrown out of the matrimonial house, if I include that, and I'm okay to give that away also, but it's still about 46 lakhs to my understanding.
Not understanding. What are the exact figures?
My lords, it's about 48 lakhs with that maintenance and about 46
Where do you
without.
get that?
My lords, in fact, I'll need some time to put it on a table with a memo and put it across. I'm happy to do that. If they're happy to buy it, my lords, your lords raised a pertinent question. What happens with a loan? I cannot be affiliated with the loan agreement. So there must be some modality explained as to how she wants to take over the loan and remove me from the liability, because I cannot be put in a situation where I'm eventually guaranteeing her in case there is a default on her part. That's the only difficulty. And also with the
ownership also. Why would she leave it? So you
no,
don't have
as
to
long
worry.
as those costs are also taken
What
over.
you have
my
to make clear is what is the amount that you have spent. And as you said, now you are ready to forego. Once the amount is received, you have to. There is no need to sell the property, so that you can place on record.
My lords, there is also one aspect. This application I have filed when both parties had agreed to sell the property. So when we were discussing in the first round of litigation, and both counsels are NOC counsels, we'll admit that before this court today. So we were not present. But what has happened between the parties is they decided at a price point of 3.5 crores. The understanding is if there is any excess amount from the sale, it would be split between the parties. It would be split between the parties after. No, please don't interrupt me. I'll show the order as well, and that is the understanding that whatever excess amount comes, the loan is paid off, the contribution is given back, and then the profits are split. Now, if that is also being taken away from me, that may also be considered. Now, if she's happy to take it on, and 3.5 is the price point she's insisting on, what is my application today before you? I'm asking for an extension in time to sell this property, and I'm saying 3.5 is not happening. Reduce it to some amount, make it a reasonable amount.
How much is the outstanding loan?
My lords,
The loan amount as of today is 1.24 crores.
1.24 crores is a loan. What according to her, she has spent an amount of rupees 90.
my lords, that is disputed by me, but okay, yes.
90. According to you, you have spent an amount of rupees
48 lakhs.
Including maintenance for
8 lakhs.
including maintenance for the corpus. That is
My
not
entire
correct.
thing would be 48. I'm not saying EMI. I'm saying EMI down payment plus some expenses.
EMI is only 35, 32 to 35 EMI and down payment.
My lords,
The
if I
rest
need to
of
be
it-
bought out, it has to be at a minimum of 48 at least.
So,
Excluding costs is what I'm saying.
As it is, these figures itself shows around 2.6. Back with all those figures.
If I may suggest, since they are now suggesting that they will take it on, can they put forward a proposal? I will also give my answers.
This is not proposal.
Can we say that yes, I will cover costs for X, Y, Z. I will release you from the road. If those terms are understood, I'm happy to do this.
Application. No, I have nothing to do. I'm representing my client here. Our only proposal is this, that we will return the down payment and the EMI.
Have you indicated in your in any written form?
I've stated it in my objections. I've said.
No, when have you received those objections?
Yesterday.
Paragraph number?
And continues to be amendable to retain the amount already invested by the respondent who properly.
Para 33.
No amount to take over the full ownership of the same. But the respondent had to resisting an offer. That is their offer. If they can be a bit more clear with this one, I'm also happy to consider it and put my figures also on record. But let it not be the only argument.
This is where is admitted. This is amount is paid. Where is your IA?
In fact, he's issued me a legal notice.
20?
Have they produced in the IA?
Where is it? Come out with your.
In fact, he's issued me a legal notice in 2023 where he admits that he's paid 32,67,786 towards EMI. It's his own figure.
I'm saying that I will do figures for EMI down payment and other expenses that need to be included.
Other expenses.
Pass orders, wasting its time. They should also make some efforts. This matter must have come before the court a dozen times before, while the negotiations were going on. I think that for all these, that's what I indicated to the earlier advocates also. The parties who come again and again with all this, they should be paying some additional amount of 1 lakh or 2 lakhs to the Legal Services Authority, so that the court will hear and some other people are also benefited by it. That's what is happening. This is all litigate. The litigant who is afford to come to the court is coming every day. How many times the court will spend time and know absolutely nothing from the parties?
You also kindly see, your ladyship.
When is the order?
He made a
this court has disposed of WP number 19102 of 2024, dated 25th July 2024, and the court has passed an order that as far as IA number 6 is concerned, the husband within a period of 1 year shall sell the property at 3.5 crores, and after clearing the bank loan and the amount that is contributed by both of them, remaining amount shall be shared between both of them equally. Now the husband has come up before this court with the instant IA seeking
extension of time by 2 years. Extension by 2 years after taking 1 year.
Seeking a modification of the order dated 25/7/2024 by a further period of 2 years. When the matter came up on the last occasion, then counsel appearing for the we are only on this point.
EMI and down payment.
With regard to this property, everything is not. What is before this court is only that property. So it is submitted that the wife is ready to take care of the EMIs, and she's ready to pay back whatever the husband has contributed towards the said flat. According to the wife, the amount is
32,67,000.
32,67,000 and odd.
786.
And according to the learned counsel appearing for the husband, the amount is 46 lakhs. 48 lakhs. Learned counsel appearing for the respondent husband submits that the husband has come before the court seeking modification of the order. Now they are coming up, they have come up with this proposal. If this proposal is placed before the court, he would also get an opportunity to place his objections. And in principle, land counsel submits that it is acceptable to the husband provided the amount is paid and all other formalities with regard to his liability towards any of the payments or any other formalities are completed, and if everything is placed in a if the wife comes up with a formal proposal with regard to all this, he's also ready for the same. In that view of the matter, the petitioner wife shall come up before this court. What exactly is the amount which the husband has paid and which she is ready to repay, and also in what way and what are the other formalities with regard to the bank loan and all, where the husband is also is a co-borrower, all the with regard to or whatever to the said proposal, he shall come back. He shall file his objections by 15th. List this matter on 18th of September. Yes, next.
Criminal hearing, cell number 13.
Yes.
Chowda Reddy.
Where is the counsel for the petitioner? Yes.
Voluntarily they have filed without issue. Voluntarily they have filed collection. Since I unable to serve the copy myself.
No observer.
Please.
Land counsel for the petitioner shall serve the copy of the writ petition on the counsel appearing for the respondent. Lists this matter on 21st of August. Yes, next.
Cell number 14. Harish Bandari, for petitioner.
Perhaps, Your Lordship, according to the roster, I don't think this matter. Perhaps, Your Lordship, this matter is related to 528, Your Lordship. The quashing I have asked.
You are seeking quashing.
Quashing.
Under which provision?
528, Your Lordship. It is not based on any orders, Your Lordship, by the. I'm total proceedings. I want to quash it.
Criminal miscellaneous has to be quashed
Yes.
in a writ petition.
Yes.
That's what I'm asking. Under which provision?
Your Lordship, 227 and 528 of the.
What is 528?
Quashing of the criminal proceedings, Your Lordship.
Quashing of the criminal proceedings in a writ petition arising out of the family court proceedings.
Yes.
Please show the law on that. Well, 227 provides for quashing of the proceedings. Give him the constitution.
Sir, 528 of BNSS.
Not BNSS, sir. 227 of the Constitution of India.
ಏನೋಡಾಗಲೇ ಎತ್ಕೊಂಡು ಹೋಗ್ತಿಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಆಫ್ ಇಂಡಿಯಾ.
It does not permit you to file a quash petition. You want to quash the 125 proceedings, file a quash petition under 482.
It's a 528 is a 482 only, Your Lordship, no BNSS.
But I'm not having a 482 procedure here.
Yes, that is
You
what
have to go before the court which
that's
is
what
having
I'm
it.
asking, Your Lordship. Perhaps this court has no roster.
So that's why it has to.
It has to go before the
bench. The writ petition is placed before the writ petition is filed to quash the proceedings in quash the proceedings which are filed under 125 CRPC. place this matter before the appropriate court. Because it is arising out of family court, it is placed before the court. Before the court having roster of the roster of 482. Yes.
Cell number 15.
Lordship, I appear for the petitioner, my lordship. Lordship, I'm seeking relief, giving direction to the state for mediation. Kindly see page 53, my lordship, page 53.
But we cannot direct the family court to dispose of 2021 MC because there is much older matters are pending before the court.
Lordship, he is a patient, TB patient, to produce the documents, and his mother is very old age. He is also suffering. He is in hospital, 83 years. And he has filed as many as, Lordship, one submission. He has filed as many as six more cases and torturing the petitioner unnecessarily. Kindly see in para 11. I have stated so many cases he has filed, and she is not cooperating to proceed the case, divorce case. We also filed objection with no objection to give divorce. In spite of it, he is not giving cooperation for the matter is now posted evidence unnecessarily taking time.
The petition is filed, seeking the following prayer. Then counsel for the petitioner submits that several matters are filed, several cases are filed by the wife against the husband, and she is not cooperating for the trial. This is an MC of 2021. The parents of the petitioner are suffering with health ailments. As such, the petition
Petitioner is also suffering from TB, my lordship. Petitioner is also suffering from
petitioner
TB.
is also suffering with TB. As such, there shall be a direction to the family court to dispose of the MC number 2026 of 2021 expeditiously. Before the family courts at Bangalore, the matters, the cases are pending, which are much older than 2021. Even the matters of 16, 17, 18, 19, 20, several matters are pending before the family courts. Hence, this court has issued
Anita SM for petitioner. Anita SM for petitioner.
Speak for short adjournment.
Why fresh matter time? Is this matter on 16th of September?
Cell number
At the request
17.
of non-counsel for the petitioner.
17.
Appearing for petitioner.
K. Prakash Reddy.
I'm challenging the orders passed on IA number 15, filed under section 26 of the Hindu Marriage Act, wherein I have sought for education and medical expenses of for the child. That has been rejected only on the ground that, my lord, earlier I filed an application of section 24 of the Hindu Marriage Act for interim maintenance to child as well as to the wife.
How much it was granted?
5,000 was granted, and thereafter after the husband has filed assets and liabilities, I have approached this honorable court. This honorable court, my lord, wide annexure C, dated 11/6/2024.
Notice to the respondent.
Interim order, my lord, stay because, my lord, here the problem is, my lord, even the enhanced amount which has been awarded by this honorable court is also not paid.
If it is not paid, you can file an appropriate application before the court. This court will not stay. Let us not go to that practice at all. Why should we stay the proceedings for no reason?
Because, my lord,
for the very same court, you please exercise that. I will not stay. Yes.
Cell number 18. Chandrasekhar.
Yes. Yes. What is the CP number? Shubha Prakash for caveator.
Interim maintenance ordered by the family court has been called in for. Lord, the family court.
Where is the order?
G, page 41.
Petition is hereby directed to pay monthly maintenance of 15,000. Litigation expenses of 15,000. What is your salary?
There is no salary. I am an ordinary tailor engaged in the.
Let us see how the court has considered this.
Lord, that has nothing has been considered.
Come to the reasoning part.
Your Lordship may kindly take, my lord, the application filed by the.
No, please come to paragraph number 11.
Hmm? The petitioner in this affidavit of assets and liabilities has stated that his education qualification is SLC, right? His general monthly expenses is of.
Where from he is spending 40,000 when he's not earning anything?
Not, his parents are his dependents. He is working as a men's tailor. He is incurring a sum of rupees 20,000 per month towards his parents, and the respondent has no occupation and no income. The respondent in an affidavit discloses assets and liabilities as stated that her education qualification is PUC. She is residing in her parent. Due to the illness, she is not working, and from 24/1/2022 to 14/3/2000, she was working as a cleaner in the type of tailoring work, and he is owner.
So you have accepted that you are spending 40,000 per month. Statement will go.
That will not probably it is. Maybe it is in the file or not. That I have to verify.
Listen smarter. On 16th of September.
One more thing, she filed an application that the super action will take and there they submit that the is filed here.
No stay is granted. No stay is granted.
Page.
How can it be? This court. The land counsel for the respondent submits a file before the registry. Land counsel for the respondent submits that the trial court is not proceeding with the matter as a writ petition is filed before this court. When there is no stay of further proceedings, just because pendency of a writ petition cannot be a reason for the court to stall the proceedings. The court is at liberty to proceed with the matter. List is matter on 11th of September. This next.
Cell number 19.
They filed an application unless and until I pay the arrears. The proceeding should not be gone further.
That whatever it is, we have not granted stay. Court can't stop the proceeding.
19.
Yes.
H.P. Prakash.
Yes, Mr. Bhan Prakash.
Petitioner minutes. The respondent has filed a FC petition for conjugal right before the family court marriage. The respondent, the petitioner before this honorable court is not the wife of the respondent. Kindly see the.
Please come to the impugned order.
The petitioner marriage was fixed on 22/4/22 April 2024.
Where is impugned order?
Impugned order. Page number.
What is there in this order? Impugned order is dated 15/4/2024. I have seen it. What is there in that?
1 minute. Some mistake has been. Page has been disputed 1 week time able to enter.
This is matter on 22nd, 21st.
Still number 20.
Notes I see.
Still number 20.
Notes I seek for a short Passover. Notes the arguing counsel is held up. Seek for a short Passover. Notes.
This is matter on 20th.
Gratefully.
Still number 21. H.V. Bhanuprakash.
Same connected matter, madam.
This
See,
also same day, like the other matter.
Literally, we have filed a application for rejectment of client malady.
We'll hear both. Yes, 22.
Connected with the both.
Well, connect this with the other matter. Yes, next one.
Schizophrenia and delusional disorder. 2 IAs were filed, one for appointment of guardian, one for summoning the documents from the hospital. Now, this thing is both the applications should have been considered at the same time and a common order be passed, because IA7 summoning the documents from the hospital is very crucial to decide IA2. Now, without that, IA2 has been decided. Though common objections are actually filed by the respondent and arguments were also addressed, IA7 is not taken up and no orders are passed on IA. Para 13 is the reasoning that is given by the family court laws.
Yes, court felt that in spite of all this, she's also accepting. She has undergone all the whatever treatment and all. In spite of that, she is like court has examined, and there is a role of the court also.
Exactly what my lords. Can the court examine her and opine that she is fit enough without the hospital records? Is my question before your lordship.
No, she
application to summon the documents, hospital records. It has to be summoned for proper adjudication of the case.
So
several judgments.
Or what those records will reveal at some point of time, she was not well.
That is, one is before marriage, which was not revealed to him.
Even the others also of a long time back.
No, 22. When he has taken her, 2022.
When is this order passed?
Look, this was passed.
This is in 2025. So a person who is not well in 2022, not necessary that till 2025 the same mental state is continuing.
Because he has every this thing to believe that she is continuing the treatment. So the hospital record.
No, for that it should have been. No, what is her present mental status is what is a relevant factor for appointing a third party, but not what was there in 2022 and 2021.
Even present, my lords, I think.
But you didn't ask for anything.
Because he had taken her in 2022. Because IA7, in fact, I have not produced. I have not filed here because IA7 was not considered at all. It is only the objections they have adopted. That is all I have filed. IA7 is, in fact, to summon the documents when he took her to the hospital.
What is the useful purpose to be served? That's what I am asking. No, it is not the present, according to you, that is not. This is a condition about 3 years back. The lady is there before the court. The lady is before the court. Court has examined her. And no, is it your case that at present also she...
Now, my lords.
That is not your case. Please come to your application, we'll see. Where is the time?
at page plus 87 is IA7, I'm sorry, 84 Millards, 84. I'm so sorry. 84. For the reasons known to in the accompanying affidavit, it is prayed that this.
No, let's see the affidavit.
Millards?
Let's see the affidavit.
Affidavit. May I?
Yes, you have not stated anything. You only stated that earlier she was taking treatment in so and so, so and so.
And has been. Millards at
She accepted it. The lady.
She accepts.
She accepted.
She accepts.
Accepting it, she says that now I am all right. So what is to be ascertained is what is her present state of mind. What is her present state of mind? So by getting 2022 records, nothing will help you.
That's even saying I.
But you didn't say that the records you want to call for that she's at present she's undergoing the treatment is not your case.
My IA7 does not say 2022 records. It just calls for Millards at page 87 Millards.
No, you specifically said on so and so date, so on so and so hospital, you have taken her at that point of time.
No, I did not mention the year at all, Millards.
Earlier in so and so hospital.
Yes.
And so hospital.
Yes. In fact, even IA7 Millards, I stick to Superintendent St. John's Medical Hospital.
What I'm saying, and when she has undergone treatment, she accepts everything. It is nothing new that you are going to ask by the summoning the documents. You are not going to produce something which is denied by her.
She says that she was taken to the hospital.
For that, I think this application will not serve any purpose. If she's denying that I'm always all right, I never underwent any medical treatment, I have never gone to the doctor and all those things, that's a different, that too, if it is immediately you file this application, is a different thing. 2022, you are separated. 2025, you are saying about something. It is that from 2022 to 2025, she will never be, patient cannot be healed.
On that count, IA2 was not decided. Hence, I was forced to file IA7, at least to summon the documents from the hospital to know the exact nature.
Let the court decide that application. Let the court decide that application.
They have not. That is address arguments. In fact, Millards, written arguments, even common were addressed. Even respondent has filed common objections. However, without adjudication of IA7, IA2 is considered. This thing is IA2, IA7 had to be considered together.
Whatever the procedure that is contemplated, how to appoint, why and when a next friend can be appointed to that the court will. There are
IA7 law was crucial.
No, that will be considered by the court on its own footing, but not.
That's not the right procedure. Is what my distinguished before your lordship is. In fact, when there is arguments also addressed for both the IAs, a common order should have been passed, and of course, the hospital records should have been summoned because they're the only means that I can get the hospital records and even confront the witness. How am I to get the records?
But the witness is saying that
witness. How am I to get the records?
But the witness is saying that she has undergone. There is no purpose of summoning the documents.
Your lordship is absolutely right. Undergone, yes, but she does not say that I'm schizophrenic or anything. She denies.
That forever, for lifelong, she'll be like that.
No, even earlier also she denies. She denies that she was ever schizophrenic. She only admits to delusional disorder. Schizophrenic, she does not. That is the only reason I'm before your lordship, because my main petition rests on this.
Bill number 23.
Plus stay of proceedings in the meanwhile, because at least until IA7 is decided,
let the IA7
that.
Yes.
20.
Yes, 23.
Kindly short Passover.
The list is smarter on 20th. Yes, next.
Monday, my lordship.
20th.
Yes. Cell number 20. For admission matter 24 is within BS.
I appeared for the petitioner.
Yes.
But can I seek, my lords, for referring this matter to the mediation?
Because both MFs are pending, so we can try, if possible, to resolve all the three matters.
The wife, my lords, filed a restitution. Restitution is allowed. Husband.
Are you up there? Wait, just a second. What can you do? Put how many? Yes.
Lords,
It can be referred. The parties submitted the matter may be referred to the mediation. Party shall appear before the Bangalore meeting
Lords,
21st.
or else, my lords, the High Court Mediation Center, my lords, because it's going on now.
It is going on.
High Court Mediation Center on 21st.
Please.
Which date?
25th.
Yes.
Cell number 25. 25 SG Bhagwan.
Appear for the respondent in this matter. Lord, in this matter.
It is a concept of the petitioner. Yes.
Made an application to vacate the order of stay.
Yes.
In the objections to it, I have stated as follows. Before the trial court, in execution proceedings in criminal miss number so and so, the petitioner, husband, has paid the first respondent a total sum of rupees 5 lakhs in installments on various dates, which are reflected in the order sheet of the trial court. The payments are as follows. Then, my lord, the petitioner had commenced making the payments much earlier to the passing of the conditional interim order by this honorable court. Going by the nomenclature of the interim order of this honorable court, from the month of October 2023 up to 31st March 2025, the petitioner has to pay the first respondent 1,80,000. He has paid her rupees 5 lakhs. She has with her an excess of rupees 3,20,000. Having such a huge sum in excess, she has no right to seek the vacating of the stay order. My only submission is, let the other side file a memo of the amount which the other.
No. An order is passed by the court.
Yes.
You have come to the court.
Yes.
They have also entered appearance.
Yes.
We'll hear the matter and dispose it off.
Any date may be fixed.
My lord, one kind submission, my lord. Your lordship may kindly see the order passed by this court on 11/2/2025, my lord.
Yes.
2024 by 4th Additional Principal Judge, Family Court, Bangalore, subject to the condition that the petitioner pays deposit rupees 10,000 per month from the date of the order passed by the Family Court till the next date of hearing. Accordingly, I number petitioner. The next sentence very clear. The petitioner shall also pay the arrears within a period of 2 months, my lord. This arrears.
The problem is there are so many, every day there are 60, 70 days. Even
I do it. I do understand.
That's why I'm not adding further.
Please.
Yes.
Cell number
Oblige.
26. B group.
Both should file a memorandum of calculation.
Huh? Who are you?
Yes. No, he's not the respondent. My elder brother.
I'm with the respondent.
Milord, I appear for the respondent, Milord.
Yes, 26.
He's not a party.
26. B. Malaswamy for petitioner. Pradeep S. Saukar.
Milord, I appear for the respondent. Milord, I pray for a short accommodation in this matter. My lord.
Counsel for the respondent seeks time. List this matter on 23rd of September.
Obliged.
Seeking time. Respondent is seeking time.
Respondent.
Yes, counsel for the petition is present. Respondent seeks time. List this matter on 23rd of September. Yes,
Obliged.
Cell number 27.
My lordship, I for the petition, my lordship. Kindly have 23rd, my lordship.
In the request of counsel, the petition lists this matter on 13th of October.
Obliged.
28. Cell number 28.
For the petitioner, my lord. My lord, this case is very simple. They have filed for maintenance, suppressing the fact that the petitioner is already is earning a sufficient income to support herself.
On 25/7/2025, an order was passed directing the respondent to file an affidavit. Then counsel for the petitioner seeks time. Finally, list the matter on 4th
My
of
lord,
September. No further time will be granted.
My lord, as my humble submission may kindly extend, there is a stay on this interim order,
It will be extended.
may kindly extend.
Extend the interim order.
For a short accommodation in this matter.
You appear for whom?
Respondents.
Where is the counsel for the petitioner?
Sorry, Your Lordship, no idea.
At the request of learned counsel, respondent lists this matter on 24th of September. Interim order earlier granted is extended till then.
Grateful, Your Lordship.
132 ordinance, serial number 33. Serial number 33, Sucheta.
Madam, serial number 32.
32 is already adjourned.
Adjourned.
Yes, 33.
Appear for petition in this case, please.
Settle the matrimony.
Huh?
They're likely to settle the matrimony.
In the trial court, madam, 13B application, mutual consent has been filed by the both the parties, madam. But in the trial court was date was fixed in 19/12/2025, my lord. But in the statutory period is not waived, my lord. Statutory period is not waived by the trial court, my lord.
It is. You want adjournment after that?
Yes, my lord.
It is submitted that both the parties have filed a petition under section 13B of the under section 13B. It is submitted that the matter is going to be listed before the trial court in the month of December. This is in January 2026. Yes.
Serial number 34.
Appear for the respondent in this case, 34.
Is there any stay?
No, my lord.
Sunil. Sunil Kumar.
Yes. Where is the respondent? Interim order is there in this?
Yes.
No representative, counsel the petition is present. No
The order is under section 26 of the Hindu Marriage Act. The petitioner has filed a petition against the husband on the ground of cruelty for divorce. During the pendency of that petition, the section 26 application has been filed.
The visitation rights on all Saturdays and Sundays and also during vacation is given to the respondent in the disposal of the petition.
Yes, please, madam. Without mentioning the timings also, madam, because
If that is mentioned, it will clarify.
madam, that is one point, madam. The child is, madam, aged about almost, now it is, madam, 6 years. But as on that date, it was 3.5 years. Madam, the child is not, he is crying when he is visiting the.
These are all
husband.
usual submissions.
But that is there, madam.
We will clarify the time.
Yes.
On all Sundays, on all Saturdays, the visitation rights, on all Saturdays and Sundays.
But my.
Where the parents are staying,
Not there in Monday only, madam.
both of them are in mind.
There only. Madam, this one is, madam, this because these holidays, madam, these 2 days are holidays.
What we do is,
Yes.
because it's small place, Saturday, we'll say from 10 to 2. And again Sunday, 4 to 7.
Actually, madam, some homeworks that and all will be there for the
That's
child.
why, that's why
So
quota is
one,
like on 10 to 2.
one day maybe not.
A whole day then.
No, one day because we at least Saturdays because
Saturday,
school.
then we'll say Sunday, or else, Sunday from morning 9 o'clock to 7 o'clock in the evening on Sunday. Then also during vacation is given Sunday and also during
Vacation, madam, because it is not
Vacation-
specified, madam, because.
That's why what we say is vacation,
Yes.
first part of the vacation, 15 days of summer, whatever it is, half of the vacation first part with the same
Madam,
time.
complete custody, madam, that will be a problem.
Like-
But madam, here, even after the order also, madam.
So 10 to 7.
uh,
It's 10 to 7 on Saturday. Vacation also, in vacation what will happen is, this 10 to 7 will be followed for all the first part of the vacation, have equal amount.
But madam, the continuous, madam, because that discretion.
It should be 15 days. If you say alternative days, we will grant.
15 days, madam, every day morning like that, madam. But if the other party, other side is there, then
Not,
that would
but
be
the
better.
court has a responsibility.
Yes, yes. But here, actually, the order is visitation raised on all Saturday, Sunday, and also during vacation is given to the respondent till the disposal of petition.
Yes.
The vacation, yes, please, Sunday, one day,
If you have to take it, vacation means, then it could be overnight custody also when we say visitation. That's why I'm saying, any vacation, summer vacation, winter vacation, any vacation, first half of the vacation to the father. In the first half, the same timings, 10 o'clock to 7 o'clock, continuously. After that, you will have.
Please,
The agreed with the orders passed in I number 2 in MC number 27 or 2022, whereby the court had ordered visitation, granted visitation right to the father on all Saturdays and Sundays, and also during vacation. The child has to be given back to the father at 7 o'clock, but the court has not mentioned about how the visitation has to go. It is submitted that when the order is passed, the boy is 3 years old. Now he is 6 years old, and he has the school and other activities. If on both the days, if the boy is the custody is given, as per the order passed by the court, the council has served the notice on the council appearing to the respondent before the trial court and filed a memo to that effect. But no wakalat is filed on behalf of the respondent. Next para, having heard the counsels on either side, there is a material on record. The court had granted, both the parties are staying in Mandya. The court had granted the visitation on Saturdays and Sundays. This court finds force in the argument of the counsel for the mother that it would be difficult for the mother if on 2 days given to take care of his homework and other things. And also with regard to the summer also, court should have clarified, considering the same, considering the welfare of the child and the convenience of the parents, balancing the interests of the parties, this court is passing the following order. 1. The mother, the father can have the visitation on every Saturday or Sunday.
Sunday.
On every Sunday, the father shall pick up the child at 10 o'clock from the mother's place and drop him back at 7 o'clock in the evening. As far as the vacations are concerned, or the vacation, both the mother and the father can have 50% of the vacation, both the 50% each, and the first part of the vacation should be with the father, and the father on all those days, the 50% days, he can pick up the child at 10 o'clock and leave him back at the mother's place at 7 o'clock, accordingly disposed of.
Number 37, Kartik Yadav for petitioner, Muhammad Umar Farooq.
For a week's accommodation.
Why?
Please, madam. Some inconvenience today.
At request of learned counsel for the petitioner, list this matter on 13.8. What you are not understanding? Yes, next.
38.
38. Petitioner.
Request of learned counsel.
They were directed to file their
I
affidavit.
filed the affidavit and I served the copy on.
Why it is not working? Yes.
The matter boils down to this. They were directed to file their affidavit explaining what are the expenses. As of now, as recorded earlier, the entire expenses towards.
Before my learned colleague submits, may I submit, Malad, the copy of the affidavit which I have filed is misplaced. Malad, I have to take another copy and argue the matter. I'm sorry, Malad, for the inconvenience. Since morning I've been trying, I don't know where I left the copy.
Appearing to the respondent, list this matter on 21st August.
Interim order may kindly.
Further adjournment.
Any day, Malad.
And the interim order earlier granted is extended till the next date of hearing. Yes, next matter.
Please,
39 dispose 30 40. Balakrishna MR, till number 40.
Yes.
I'm for the petitioner in this matter, my lord.
Yes.
The entire arrears has been paid. Instead of filing the affidavit, I have cleared the entire arrears. Today I have paid a sum of 4,10,000 DD. And to explore the possibility of settlement, let the matter be referred for mediation. both the parties have agreed to settle the matter.
When the matter came up today, and counsel appearing for the petitioner submits that he has cleared the entire arrears.
Today,
Earlier, he has paid. The outstanding amount was 7,10,000. Earlier, on the last occasion, the matter came up on 37/20/25. A DD for an amount of rupees 3 lakh is handed over to the respondent. Today, he had paid an amount of rupees 4,10,000.
4,10,000, yes.
4,10,000.
Yes.
It is submitted that there is a likelihood of settlement and the matter may be referred to the mediation. Both the parties shall appear before the Bangalore mediation.
No, mediation center Mangalore.
Yes, 42.
42.
Responded. Lord, the trial court has been passed the order 5,000 of the maintenance amount to the wife and child, my lord.
5,000
5,000 rupees.
Maintenance amount, my lord.
is book.
My lord, today I am paying a 30,000 rupees DD
Hmm.
as they have not accepted in before the lower court. Therefore, I constrain to
You
find
don't want money?
No, my lord, what happened? Last time we moved the 151 CPC application. They are not paid the.
Whatever it is, your client requires money, take the money.
No, no.
Take the DD.
What happened, my lord? Last time we were ready to accept the DD, but they have not paid the entire amount. That is 1,20,000.
30,000 is paid, you will not accept.
No, we are ready to accept, my
First
lord.
accept the
Please,
DD.
please.
Then counsel for the respondent submits that. Has given a DD for an amount of rupees 30,000.
Please.
Forwarded the DD to the counsel appearing for the petitioner. And what is outstanding as of now?
1,20,000 total.
It is submitted that 1,20,000. Deducting this 30 or in
No,
addition?
no,
No, it is
including.
deducting.
Total outstanding is 1,20,000.
From the month of
As
September
30
24 onwards.
30,000 is already paid. Now according to the council, the arrears are 1 lakh, the arrears are 90,000.
Please.
The arrears are 90,000. Hmm.
Let the petitioner may be directed to receive the same in the trial court.
What?
The balance amount, my lord. He is not receiving the trial court.
No, no, the what?
You are ready to pay 90,000.
What happened, my lord? Last date.
1 minute
Please,
at least.
please.
What will pass is, let him have the visitation on the weekends. Let him not take the child to the home. Let him not take home the child. Let him exercise the visitation outside.
Your Honor, it is a humble prayer. If the court could grant visitation rights and interim custody as provided by the family court, only 2 days in a month, because in presence of the petition.
The visitation is not at all going on. Problem is how to take the issue forward is either of the parties are not understanding. No, your client, this matter, I'll keep it pending. Let him have the
One
visitation,
submission.
let him have. No, the order is passed by the family court. Did you have the visitation?
Your Honor, we have advised, the advocates have advised the respondent in this case that do not go to the house of the petitioner in this case, because she instigates violence. She harasses, neighbors come in, they threaten. So instead of that, we have told.
Matter will be kept. I will pass an interim order. We will see 2-3 weeks. What transpires in those 2-3 weeks, you please tell the court. If either of the parties are violating the order passed by the court, this court will deal the matter appropriately.
Your Honor, in the
You can't, your client, your advocate is.
previously, the petitioner in this case has violated all the orders. When the family court had passed an interim order in IA 7.
Already I heard all.
Yes, about that itself. The main issue is when the petitioner is in presence, when the respondent goes to pick the children, she instigates violence. It goes back to again fighting. She starts threatening, harassing, and she's filed multiple NCRs. Because of that reason, we advised our client that do not go until the apex court passes a order. We had advised our client do not go. That is the reason he did not go for any visitations.
Yes.
In the application, he is not particular about custody. What he said is physically or virtually custody may be given. That is the application.
Come to the order.
That is 55 at page number 55. In page number 55, application is there. In page number 55.
Where is the order?
Order is
Approved
at
order.
page number 35. In page number 35. First order.
Please come. I number 6 filed by you.
I number 6
I
is
number
filed by
5 is
the
filed by the
respondent father.
father seeking change of place for picking of his children for the interim custody is allowed. And the application filed by the wife seeking modification or discharge of the interim order granting the visitation to the father is dismissed. The petitioner, the father is permitted to pick up both the children as ordered on IA number 2, instead from the residence of his in-laws from nearby police station, and drop back at the same place to the custody of the other. You have not questioned the order in IA number 2.
Both the application are questioned. Both the orders are questioned.
How can you question in one writ petition all these orders?
I have paid double fees.
That's not the way.
That annexure A and annexure B both.
This is the order. I will only look at one order. Because one writ
Annexure
petition-
A and B, I have questioned.
Your Honor, one submission. It would be great if the Honorable Court.
Yes.
The respondents filed a divorce petition before the family court for seeking divorce.
Hmm.
And petition also filed counterclaim seeking divorce, my lord.
Hmm.
So they filed one more application for seeking maintenance. But in that we have filed an application seeking our employment details from the employer where she was working. Subsequently, representative of the employer.
Where is the included order?
My lords may come at annexure N, my lords. Impugned order will, my lords may find it at page 148.
148. Employer has furnished the details. On the basis of the details obtained from the representative employer, we have filed an application. The employer furnished details stating that she has resigned from the company. So on that basis, whatever details available in the salary slip, we have filed an application to seek details from the PF commissioner, where the entire details, if she left the company, the details are available with PF commissioner.
So it is like you want a ticket to the place where you.
Otherwise, it's difficult.
No, you don't know where is the place. You just
We
want a
don't know
ticket.
because it's Bangalore. It is difficult to locate where she is
And
working.
it's not the court's duty to do it.
It is difficult to locate where she is
And
working.
it's not the court's duty to do it.
And in
No,
fact,
my lord, I have filed an
maybe-
application.
Hmm?
In fact, my lords may kindly come to the same page number 145 for a moment. IA number 5 was filed by the petitioner before this court under 91 and 311, telling that the petitioner is working. To the said application, I have filed an objection stating that I am not working. On the account of it, they said I am lying before the court, and the manager of the said company was summoned. He was produced before the court. He has produced the documents telling that.
See, page number 115. In that, she has taken a lot of loans, and kindly page number 121. But she has stated nothing. No account details she has furnished. When she obtained loan, unless she is working, she cannot repay the loan. And moreover, without
Only working people can take.
no, and moreover, bank, she at least repayment of the loan, at least bank details. That,
For that you can ask whatever you want. This
no,
is not
my
an
lord,
ask.
actually, if you summon the representative PF commission,
Without even saying where she is working, you just ask like
No,
it is an
it's-
injunction against the entire world. It
Not-
can't be
not
And
like
it is
my
not
lord,
a
in the city
discovery
like
also.
Bangalore,
To
it is
perform the
difficult.
obligation, he cannot mandate the court, my lord.
filed by the husband under section And the present writ petition is filed, agreed with orders passed in I number 6, dated, what is the date of the order?
15/10/2024.
15/10/2024, whereby the court had dismissed an application that is filed under section 91.
No, not 1510.
Huh?
Correct.
1510.
Under section 91, read with section 311 of the CPC. The husband has filed the IA directing the Regional Provident Fund Commissioner Bangalore is deputed person to come before the court for furnishing the employee details of the wife and also giving evidence. Earlier, he had filed an IA seeking production of the documents directing the employer of the wife furnishing the documents. The husband, without ascertaining where actually the wife is working, he has sought the Regional Provident Fund Commissioner to furnish the details. The court has observed that it's a duty of the husband to ascertain the actual employment of the wife, and he cannot ask somebody to furnish documents required without ascertaining. Accordingly, had dismissed the petition. Land counsel that he is not working, but still one after the other they are coming up with this kind of application. It is submitted that the husband has an obligation to take care of the wife, and without taking care of the said obligation, he is coming up with these kind of frivolous petitions. Next part. Having heard the counsels on either side, there is the material on record. The application that is filed by the husband does not make any. The application is without any basis. When it is his case he cannot ask for the summons to be issued to the Provident Fund Commissioner on his on assuming on his assumptions and presumptions that the wife is working, and that kind of general orders cannot be passed by the court. It is for the husband to give the details, and basing on that, the court will be passing the orders. Interestingly, in this case, already according to him, she is working with some person, and that person was summoned earlier, and he has stated before the court that she is not working.
She resigned. She has resigned.
Resigned from the
Yes,
company.
resigned. And this kind of an activity, court cannot take up, and court had rightly dismissed the petition, and this court finds no reasons to interfere. Next.
May I make one submission, my lords?
45.
Dispose of within a period of 1 year.
Which year is the MC?
The criminal miscellaneous. Mean not
And moreover, my
prosecuting.
lord-
The child is also there, my lord.
Where is that? Which court?
All the matters are in 2023. It has been
Which court?
family court, my lords.
My lord, they are not at all appearing for evidence in the family court.
Yes, anyway, I'm not granting any such.
Obliged.
But if the court is
Obliged.
because of within.
45, Loita Shubhanakar.
In this case, I am for the petitioner in this case. I am appearing through VC. Not
Yes.
through VC, I am appearing.
Yes.
My short point is this, order 18 rule 17 application came to be dismissed.
Yes. Who filed the MC, husband or wife?
Husband.
Husband has filed, I have filed detailed objection.
MC on what ground?
No,
Not-
on grounds of
Necessary.
cruelty and
And now who filed the IA under order 6 rule 17?
they have filed. Respondent
Has filed.
responded.
18 rule 17, recall of the
18.
witness, further cross examination.
When was the cross examination of that particular witness is over?
18/1/2025.
My lord,
18/1.
2025. In next date of hearing, I have filed application seeking recall and reopen of the stage.
Immediately
And-
next day.
Please,
no. My lord, this is the third time they have come up with the same application, seeking the honorable court to permit them to cross-examine PW1. Lord, first time, my lord, if my lords may look into the order sheet, my lord. Soon after notice was issued, they came on record. They filed wakalat on page number 14 of the petition, my lord, writ petition. Number 14 of the writ petition, which has the order sheet, my lord. On 8/3/2022, they come on power. Thereafter, matter was referred for mediation.
We'll see 29. He's paying the submission. Read 29.
He's 29. Yes, my lord. My lord, here also, the court has noticed.
Read page 29, paragraph number 2.
29, read from 28 or 29?
29, these being the submissions.
These being the submissions, after perusal of the records, it is seen that several adjournments were taken for further cross-examination, and it is rejected ultimately, and further cross-examination taken as nil. Now, applications are filed when the case is posted for arguments. When this court inclined to the third time they have filed this application.
What we do is, we'll fix a date for cross-examination, and we'll also call for what is the pendency in this court, and we'll give a direction to dispose of the matter.
Within 3 months,
Call for this, you called first additional?
A third additional senior civil court.
Third additional senior civil judge court, the registry to obtain the information, what is the pendency of the third or first?
Third additional.
Third additional senior civil judge, city civil court, list this matter on 28th. That day we will dispose of this matter.
Lord, and cost, my lord, the petitioner herein is.
That day will pass, that day you can submit. Yes.
Cell number 46. Gita Devi.
Interim order earlier granted is extended till then. Yes.
46 Gita Devi.
Hoping for the petitioner, my lord. Lord, it's a
My lords, I appear for the respondent in this matter. My lords, due to a minor inconvenience as the advocate on record is unwell, my lords, I seek for a short accommodation regarding this matter, my lords.
Lord, when this matter comes, they seek short accommodation. Earlier, Lord, before your lordship, the matter has been disposed of. In that, they have filed an application for modification.
Finally, what we'll do is, we'll have it on Monday.
Please.
At the request of counsel, the respondent list is on
My
Monday.
lords, I request your lordships to have it on 20th, my lords.
When is 20th?
20th is 100. That's it.
20th will take
Please,
up.
madam.
No further adjournments will be granted. Please remind the court on that day.
Please.
Yes, next.
Cell number 47. Colin Kenneth Ward, party in
But I
person.
have not received the copy of the petition, my
Maheshwari.
lord, because the hand summons was provided.
Give them the copy.
If I may
We'll
permit,
have it on Monday.
if I may be permitted to file a memo, I sent it to the council, they rejected it.
Going to all that. Take
I'll serve them the soft copy, right?
counsel for the respondent submits that the papers are not served. The party in person has served the papers before the court on the counsel appearing for the respondent. This is matter on Tuesday, not on Monday.
Much obliged.
Yes, Tuesday. Yes, next.
For judgment.
Is it reserved?
No, my lord, the respondent has filed a memo stating that they don't need maintenance. They are only claiming the arrears, my lords.
Yes, that for that.
Yes, my lords. So my lords had told that pass orders on this matter, and it was listed for judgment. On the last occasion also, it was listed for judgment.
No. For judgment means not for reserved.
Judgment, my lords.
So like, because I want that information, that's why it is posted. Yes, so you want only areas. Is this the case that you are employed thereafter?
Yes,
my lord,
my
my
lords.
respectful submission is, order was passed in the month of November, please, my lord.
No, please give the details. When was the IA for maintenance?
Along with the petition, it was filed, my lord.
My lords, the IA for maintenance was filed on 29th November 2021, my lords. Thereafter, the order came to be passed on 4th of November 2023. My lords, one thing I want to highlight is that the petitioner counsel has been telling that we have not stated before the.
Forget about it. Then when?
My lords, she started
from when you are
working.
employed?
She started working from the month of September 2023. So we are asking.
September 2023.
Yes, my lords.
So according to you, are entitled for maintenance from 29/11/2021 till September 2023.
Yes, my lords. That's the only.
how
arrears.
many?
Yes, my lords. That's the only.
How many
arrears.
months?
I have
It
the
is
calculation.
13 months, my lords.
I have the calculation. If
Where
my-
is that?
No, I'll just, rough calculation I have, ma'am. So if that is the case, my lord, the total arrears should be 13 lakhs
No,
20,000.
how many months?
It will be 23 months, my lord.
23 months. And what is the amount granted by the court?
60,000 per month.
How much?
60,000.
per month.
What is your income?
53 lakh as on 2021, please, my lords.
So what remains is?
The remaining is 8 lakhs 20,000.
So what remains is?
The remaining is 8 lakhs 20,000, my lords.
So my only submission is that, my lord, the memo, my lord, was filed subsequent to I filing this writ petition. Order was passed in the month of November. She was employed in the month of September.
My lord, if that
Let's
memo
not
was,
go into all those aspects, Mr.
no, one
Thomas.
I
submission,
have
my
a
lord.
clarification on that also,
Let
my
me,
lords.
let me clear, my lord. If the memo was filed prior to passing the order, my lord, the contention, the findings of the lower court would have been different, my lord. That is one part. Second part, with regard to the income, my lord, as on 2021, I had 55 lakhs 32,000 income. It is a declared asset. My lord, after that, my lord, my 30 years of marriages broke down. 2 of my daughters has left. I am staying alone. And I run a proprietary concern. So that may be considered, and my lord, the amount may be.
Why should it be reduced? What is your income as of now?
My lord, as on today, my lord, I have come down to 1/4, my lord. There is no one. I am alone. My 30 years of marriage broke down. 2 of my major daughters
But
left.
only on the point of your income, not on those facts.
True.
What is your income as of now?
I have come down to 1/4, my lord. Now.
You have to quantify
I don't have the
it.
perfect figure, but as per my client's instruction, I
It
will
has come down to 1/4.
because I could not concentrate on my business. Everyone left. I stayed liability affidavit filed by the respondent. She says that she has no income, but the bank statement, whatever is annexed to the assets and liability affidavit, there it shows, my lord, she is
On the
receiving the
last
income.
occasion, you have accepted for
Please.
this, and now you can starting again another argument.
No, I am not accepted that I will pay in the last occasion.
No, you were said your only ground of attack on the last occasion was she's earning and that fact was not disclosed.
Please.
You were only on that point. Then when she said, I have also stated that I am earning, I am only asking for the maintenance for that period. Only for calculation of that, the matter is adjourned to today. Nothing else.
No.
The matter was reserved for judgment in the month of April 2023. Thereafter, the order came to be passed in November, my lords. There was no way that we could go and advance the matter when it's reserved for orders.
No, multiple
Firstly.
dates was there. in
Secondly, my
between.
lords, he says that his income is come down to 1/4. My lords, subsequent to filing of this writ petition, he's bought a Audi Q8, which is worth 60 lakhs.
Please come. Agreed with the orders passed on I number 2 in MC number 6241 of 2021, dated 4th November 2023, whereby the court had granted 60,000 as maintenance to the wife. The husband is before this court. Then counsel appearing with the husband submits that as on the day when the petition is, as on the day, the income of the husband is
532, please.
Huh?
5532.
55 lakhs 32,000 was his annual income. As in view of the disputes and all, as he is not able to concentrate on the business, the income has substantially come down to 1/4. It is submitted that the order is passed in the month of November 2023, and the wife is working from September 2023, and this aspect was suppressed by the wife. It is submitted that if this aspect is brought to the notice of the court, the order of the court would have been altogether different. It is submitted that as per the orders passed by this court, he has already paid an amount of rupees. It is further submitted that as there is suppression and misrepresentation of facts, the petition has to be her petition seeking maintenance has to be dismissed, and she is not entitled for any maintenance. Learned counsel appearing for the respondent wife submits that the matter was reserved in the month of April 2023, and the same was pronounced on 4/11/2023. The wife got a job, and in fact, not rightly, the granted 60,000. In fact, the same is on the lower side. It is submitted that the submission of the counsel that his income has come down is not correct, and according to her, he has bought a luxury car worth 60 lakhs, which is denied by the learned counsel appearing for the petitioner. Next para.
My lords, he's purchased is after filing the writ petition, maybe.
Because any of those kind of submissions we can't.
My lords,
take on.
my application for alimony is also pending. That's the only thing.
No, that we can't. In this case, we can't consider
Please,
without
my
any
lords,
pleadings. The counsels on either side and produce the material on record. Undisputedly, as on the date the application is filed, his income is 55 lakhs and odd, and the court has granted 60,000. When a husband's income is 55 lakhs per annum, and that is at least 4.6 lakhs per month, the granting 60,000 maintenance by the court cannot be said that it is on the higher side. Then coming to the suppression of fact, as rightly submitted by the learned counsel appearing for the wife, This court this court is a view that there is no suppression on the part of the wife. When the matter came up before the court, it submitted that she is working and she is only, she's seeking for maintenance for the interregnum period between 29/11/2021 till September 2023, till she is employed. If that interregnum period is about 23 months, the court had granted 60,000, that it comes to 13,20,000. It is submitted that already 5 lakh is paid and the remaining amount is 8,20,000. Accordingly, the writ petition is disposed of, directing the petitioner to pay an amount of rupees 8,20,000 is
Produce the bank statements of the company where the petitioner is a chief executive officer. Produce the bank statements. They'll
What
have
it
to
shows?
reply on them.
Please, Your Lordship.
You have any objections to
Please,
find
Your
to
Lordship,
that?
I do have objections to that bank statements, Your Lordship. Lordships can kindly turn to page number 7 of the memo which they have produced. The account numbers which they have sent, which they have given, Your Lordship, there are 2 account numbers, Your Lordship. I'll only go
Every
through
time
the,
this matter is coming at 4:42, the list is matter on 9th, delete from judgment, post it as part heard on the top of the list on that day.
Lordship, any short adjournment, Your Lordship.
2nd of September. There are so many matters. Yes,
Number
2nd.
50.
Interim order. my kind.
Interim
May
order
at
earlier
least be
granted
complied
rejection.
to, maybe order to comply with the interim order.
I have complied with
What
my
is
lords.
Interim
I've
order
sent the
shall
amount.
be
the last month.
interim order shall be complied with, or else the stay granted by this court's transvacated. Yes, next.
Then number 50, final hearing. Karumbaya.
Yes.
My lord, I'm for the husband, my lord.
There is a counsel for the it is served. Yes, give the bill. How much is the amount granted?
My lord, in fact, maintenance was cancelled, my lord. Kindly look at page.
This is a petition filed by?
This is a petition filed by the husband. But in this criminal miscellaneous petition for enhancement of maintenance, maintenance was cancelled, my lord. Kindly look at page 20, which is the order. Till September 2014, the husband was paying maintenance, my lord, until they found out that the wife is earning, my lord. So here.
And what is questioned before this court?
No, my lord. So from 1/1/2018, the court has ordered him to stop paying maintenance. My lord, the petition was filed.
What is impugned before this court?
My lord?
What is impugned in this court before that he is not entitled, no maintenance should be given to her at any point of time?
Because she's been earning from 2010, my lord, and we've been paying maintenance from 2007.
Where is the evidence for that?
My lord, it's all, that's not disputed, my lord. Kindly look at page 13, my lord, where it states that the
Read
petition.
from paragraph number 8.
Yes. It is the specific case of the petitioner that he has no earning source as he's lost his employment and that there is reduced earning potentiality, and that the respondent being a well graduate and having earning source and an employed person having salary, and she is hailing from a well-to-do family, and on these changed circumstances pleaded in this petition, the petitioner has submitted his affidavit in lieu of examination in chief. My lord, the relevant portion is at page 13, my
To
lord.
understand the facts.
Yes. He has relied upon the documents supporting his case. They are Exhibit P1, the certified copy of the order, wherein the respondent was granted maintenance allowance of rupees 2,000 per month from the date of filing of the petition and rupees 2,200 from the date of the order passed therein, with 5% increased maintenance amount per year on the amount last paid. Exhibit P2, statement of HDFC bank account of the respondent in 3 pages, showing the entries of amounts other than the maintenance amount paid by the petitioner. Exhibit P3 and P4 are the certified copy of the application under RTI Act. Exhibit P6 is the demand register extract belonging
to paragraph number 9.
Yes, ma'am. My lord, in page 13, thus, it is the communication letter to the petitioner about non-functioning of the said factory at catering the petition governments has stated that the litigations under matrimonial proceedings and also the criminal proceedings and grant of decree for divorce in his favor dissolving his marriage with the respondent solemnized on 4/3/2004 and the maintenance petitions filed by her and the results of the same, specifically criminal miscellaneous number 332/2004 being challenged before the Honorable High Court of Karnataka was dismissed, and that the petition for enhancement of maintenance filed by the respondent was also dismissed, and about the status of the respondent and her earning potentiality and a comfortable residence, and about his reduction in the earning potentiality, and that he has no avocation because of closure of the sugar factories in which he was working. And he was living with his parents, and his termination from his service and his stay is at the mercy of his father, who was drawing a pension and providing necessary amenities. The petitioner is a degree holder of sugar technology and only qualified for work in the industry, and the respondent is a computer graduate, and it is more lucrative and job oriented technical course, and she stands in the better footing than the petitioner in earning potentiality and the capacity, and she is a computer literate and earning salary of more than rupees 8,000. My lord, we've produced documents as well, my lord, to show that she was earning 8,000 and working in a private firm which was brought on record, and it has been considered in the said order. He further deposed, referring the said documents and about the respondent's earning capacity, that she has got the income other than the maintenance allowed paid by him, and she can maintain herself, and that there is a change in the pecuniary ability and also the earning ability of the respondent in leading an independent life. Since the respondent has not contested the petition, and also she has not cross-examined PW1 nor stepped into the witness of his employment, and it is now no more remained, and he has no earning source of income, and he is almost unemployed, and on this ground he is unable to pay maintenance to his divorced wife, and it is therefore held to be the change in circumstances and brought on record by the petitioner, and certainly this change in circumstances have reduced his earnings and earning potentiality, and thus it is one of the reasonable ground to cancel maintenance amount granted to the respondent.
Come to paragraph number 13.
Yes, madam. Other petitions filed by the respondent for recovery of arrears of maintenance and the orders passed in those cases have been challenged, but there is specific observation in Exhibit P3, and the petitioner herein has made it clear that the order passed in criminal miscellaneous petition dated 7/9/2007 has reached its finality, and as he had filed the revision petition in RPFC number 63/2009 challenging the order passed in criminal miscellaneous petition. But it was dismissed confirming the final order. Thus, no revision petition challenging the said order is pending. Therefore, the order passed in that petition dated 7/9/2007 has reached its finality. The miscellaneous
Above 4 lines from the top. That's between December 2017 and January 2018.
He had switched jobs as well, my lord.
Till such time you are having the employment. Exhibit P10 is dated 21/12/2017.
Yes, madam.
Thus, it is a communication letter to the petitioner about non-functioning of said factory at so and so, and is brought on record by the petitioner regarding his efforts to secure so and so. So that's what the court has observed.
My lord, she was also earning, my lord.
There is nothing on record. She is earning from 2018. That's a finding.
No, my lord. Page 16, where she did not pursue her further studies, and
That
she
is only an observation by the court.
My lord, but there is
Having,
this-
having a qualified women, why she is not working is a passing observation. Now, earlier order has attained finality, you filed a revision, revision was dismissed, you have not taken it further. So, court, as far as that order is concerned, it is already, whatever the arrears that are flowing from that date, you have to pay.
My lord, but we've produced memo for production of documents where this is a statement of accounts, my lord. From 2007, she's been earning, my lord. And we've produced it as well. Where
is it? That is exhibit?
Yes, my lord. No, we've produced it, my lord,
Not
separately.
here, in the, before the trial court.
Yes.
Before the trial court.
Yes, we've produced
Exhibit, what is the exhibit?
One second. Exhibit R1, my lord, which is the bank account statement of HDFC Bank. Where
And also the petitioner. This is the matter on 9th of September. And also the petitioner. This is the matter on 9th of September.
Pass over the serial number 10.
Lord, before the tribunal, I have not yet received any amount, my lord. As per order of the trial court, my lord, total, my lord, 3,20,000, out of which, my lord,
We will decide, that we will decide on the next date of hearing.
my lord, matter 53.
53, it is gone to 10-9.
Yes.
My lord,
Next.
my lord, may consent, this 53, my lord, matter may be posted for admission, my lord, because large rate of hearing, delay has been condoned, my lordship, on 21/7/2000, my lord, 25. Thereafter, my lord, matter is,
He is saying that he will serve you the paper
No,
today.
please,
And after that, we can hear the matter.
my request, my lord, matter may be posted top of the list, my lord, that is my, matter is coming, my lord, finally.
Yes.
Have it Monday, Milan. I will file a better affidavit. Serial number 10.
Whatever it is, I'm going to dismiss it. It's only your buying time. This is a matter on 13, on 2nd of September as part heard.
2nd of September. Yes.
Yes. Any papers?
ಹೇಳಿ ಸರ್
ಮೇಡಮ್ ಅದು 53 ಯಾವ ಡೇಟ್ ಕೊಟ್ರು ಮೇಡಮ್?
10-9.
ಥ್ಯಾಂಕ್ಸ್ ಮೇಡಮ್.
9-9 ಹೌದಾ? ಒಂದು ನಿಮಿಷ 9-9 ಅಂತೆ ಸರ್.
ಓಕೆ ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್, ಥ್ಯಾಂಕ್ ಯು.
53 9-9 53 ಯಾವಾಗ? 9-9 ಸರಿ ಓಕೆ. 52 ಆಲ್ಸೋ 9-9. ಅದು ಮಾರ್ನಿಂಗ್ಗೆ ಟೈಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಸರ್.
ಆರ್ಡರ್ ಶೀಟ್ ಆ ಕಡೆ ಸರ್ ಮೇಡಮ್ 10 ಏನೋ ಆರ್ಡರ್ ಶೀಟ್ ಬೇಕಂತ